I beg your pardon.
Yes, please.
Item 22.
Yes, 22.
It is matter is relating to Odisha Government Bank. After amalgamation, the name
So
has
that
been,
order has to be passed.
yes, I have filed IA, but IA is not on record.
IA number
7867 of 2025.
7625.
Copy also I have.
Odisha Gramin Bank has merged with
Utkal Gramin Bank. There are amalgamated.
Odisha Gramin Bank.
Gramin Bank.
The other bank is Utkal Gramin Bank.
New one. New entity.
Both Odisha Gram Bank and Utkal Gramin Bank amalgamated, and now it is become Odisha Gramin Bank. Similar also item 2.
So date sir. Date करो so बारी. Date.
24th, Mr. Hon'Ble was there. He was consented for 24th.
Just a second. We सातरे अपन एडा अपन आईए टा को सेतरो आसीबो रेकॉर्ड रे कंसिडर
आगे आईए आसो ऑर्डर रे आसो अपन ऑर्डर पास करिवे एटा खाली जेहेतु रेकॉर्ड रे नाही
पर डिफेक्ट हम जाननी जहां अपन देखि देबो
in item 20
yes
I will be finding the fresh vina material.
अपन को नाटा
Item
Show me that on behalf of Mr. Nanda.
similar also the item
DAS.
Yes, sir.
Well, similar order in item 14 also.
1 second, I have not completed 22 because I'm myself I'm taking it.
Sorry.
No, it's fine. Tomorrow.
No, today I'll file.
So, who is that? 2nd of July after the
Well, item 14.
Can it be possible, Mr. Nanda?
Item, sorry.
For 24th, will it be possible? 24th June.
Don't dump all matters in 4 days. I mean, for 7 years, 8 years, nothing is happening, and suddenly in 4 days, everything will happen.
No, that's all. I will.
But it sounds magical.
No.
Magical and something
Item 14, my lord.
completely divine.
Sorry, sir.
Second July, 3rd July.
Second. Then in fact, within 3 days, 3 weeks, no, rather, yes. 23rd to 9th is 3 weeks. Adjust beyond that, price
July.
Item.
July, 2nd July. Reopening week, 2nd week.
Item 19, my lord.
Yes.
My lord, I have this is the same thing, but I have not filed the IA. I didn't know that it.
Okay, IA to be filed. So, Ms. Das, please take note of this.
Yes, sir.
You have to also again, since it's a new entity, you file wherever you are appearing, obtain it.
Yes, sir.
And I will change the council because one of the council said that I am not sure whether I will appear. I think just a second. Just look at the. Saugata Das at Puri.
Yes, my lord.
Wait.
Yes, my lord.
Item 14.
Same, Ms. Das, your presence is marked in item 19.
Yes, sir. I'll file
for the new bank.
Yes, sir.
14 also, I will file a petition, my lord, for amendment.
14 is my case.
Sorry, 19, my lord. 19 is my case. That's the same thing.
19 I have Mr. Patak have recorded. I have recorded that you will file IE, bringing in the new entity to on record for amendment. Then the amended cost will be filed after the order is passed.
Let it come on July 2nd.
The opposite party, they will be. The date Mr. Bari.
2nd July.
In sir.
Item 25.
Item 14, my lord.
In sir.
Item 14.
Mr. Patak, sir.
Item 14.
1-4.
That VSF matter, I have to take instruction.
In presence of the other side.
Yes, sir. My friend, they are for petitioner. I am for the VSF.
This can be closed actually. The effort is after 11 years, Mr. Maharana, Mr. Pasu, this can be closed.
Yes, of course. Well, that is the
that is only hope.
After vacation.
And it is on a short point. If that legal issue is answered, this has to go either way.
Yes, fine.
Date में agree करो साथ Mr. Pasu.
Well, item 25.
3 week भीतर सब adjust करो. I think 3 week अच्छी. 23 की साथ 9 भीतर adjust कर देते. तो छुट्टी है. कभी 27 छुट्टी अच्छी. No, Sat is Monday. तेईस रे 11 भीतर 27 टा छुट्टी ଅଛି 23 रे 11 भीतर adjust କରିକି
Item 25, my lord.
25
So Odisha Government Bank matter. I am for the opposite party. I will hand over the gazette notification of petitioner. That will go for amendment by the petitioner.
Mr. Senapati is there.
So now I will give them the gazette notification today. I have informed them that this is the position.
IA they have filed.
No, not filed, but I will give the gazette notification today to him. I have informed him.
IA to be filed.
To be filed.
So Mr. Panda mentioned that the same order cannot be passed. So Panda mentioned IA. So you will also have to file Wakalatnama by the
No, I am already appearing in the for the Odisha Government Bank. I will hand over the gazette notification to the petitioner today.
No, please be clear on your. Are you authorized to file Wakalatnama on behalf of Grameen Bank?
Yes, I will appear. I am authorized. I am authorized.
Go to Wakalatnama.
Then today I am not, but I have been authorized and got this over.
The authorization beyond Wakalatnama, there is no concept as far as law is concerned.
But let it come. I will file.
Advocates Act makes it very simple. File Wakalatnama.
I will file fresh Wakalatnama.
So that is up to
I will
you.
fresh Wakalatnama. Because my name is there, I will file it.
No, that's not an issue. That whether your presence is not doubted, but whether because this question will be this is a serious question. Somebody appearing, then suppose you lose the matter, then you writ appeal or before the Supreme Court, you will say that we never filed, we were never represented.
I will file.
And automatic filing of Wakalatnama is not there. The proceedings will be adopted, fine. But the Wakalatnama for the new entity, it is not automatic. There is no concept also. Date Gorandu, sir.
Item 24, my lord.
So by that date, Mr. Kanungo, you
I will file my power.
Yes.
Item 24, my lord.
Also, it can't be by memo. Substitution cannot be allowed. It has to be IA. Substantive,
Yes.
because it's a substantial amendment of the pleadings.
Item 24, my lord. I am for the corporation. We have pray for an adjournment.
Corporation etre kon achon?
Opposite party achan.
On whose behalf?
Mr. Samir Kumar Mishra.
Your name, sir?
Chandrasekhar Padi.
You are right. CS or Khali C lecture?
CS.
CS Padi.
Let it come after vacation.
Other side, Ashok Padi right padega.
I am appealing for the Hon'Ble Mr. UK Sama.
You are Mr. MR Mahapatra.
Yes, ma'am.
The date Gorandu.
No, sir.
Again?
No, sir.
Obliged, my lord.
Pardon,
No,
my-
sir. You are for the civil supply?
Yes.
Pardon, my lord.
Yes, please.
Item number 2,
Obliged.
my lord.
Puta ଟିକେ room ଲାଗା 24 ପାଇଁ ଆପଣ mention କଲାରୁ ପଖାଳ ଅଛି ଉପରଓଳି ତ ଆପଣ ଏମସି କରୁଛନ୍ତି ଆଜ୍ଞା we mention କରୁଛନ୍ତି
Item 15.
if you want to have ପଖାଳ for two also you can have it no problem.
My lord, item 35.
Yet to happen. That is
My-
why liberal-
My lord, item 12, your lords.
ଟିକେ ଆପଣ ଏଇଟା court room mention ଗୁଡାକ ସରୁ.
Item
Item 35, my lord.
Okay.
35 Mr. Rai, anyone from Mr. Chamber?
Yes.
I am your man.
Yes, Annapurna.
My lord,
Give a date, Sabari.
No, sir.
Like there is an interim order.
9/7/25 interim order to continue.
Yes, my lord.
My
lord,
all the matters, whichever is urgent, there will be order. It's not that now it is happening. So anyone not present objecting, it will be subject to them.
My lord, item 20.
36 per month.
I have to file a rejoinder after matter.
Date Gorandu, Mr. Bari.
No, sir. My lord,
Item
item 11,
15.
my lord.
Just a second.
No, sir.
Item 15.
Item 20, my lord.
20.
I am for the opposite party, my lord. Pray after vacation, my lord. Other side is also.
କିଏ ଅଛନ୍ତି?
Yes, my lord, yes.
ଆପଣଙ୍କର you are Mr. Behra.
Hi.
PK Behra. Ambika Prasad Mishra. Date କରନ୍ତୁ Mr. Bari.
No, sir.
My lord, 28.
9/7/25 Mr. Bari.
Obliged,
My lord, item 11, my lord.
1/5.
1/5. On behalf of Mr. My lord,
Acharya, you are appearing for whom?
my lord, I'm for the petitioner, my lord. I do not have the power, my lord, because Mr. Rizvi was appearing in this matter.
Yes, the petitioner has obtained change, obtained transfer.
Yes, my lord.
ଆପଣଙ୍କ ପୁରା ନାଁଟା?
Parthasarathi Acharya.
The writing PS.
Yes, my lord. My lord, may keep it to 15.
So Rizvi's name is to be deleted
My lord, he may be there because he.
along with Mr. Rizvi.
Yes, ma'am.
Who is for the other side? Mahanadi Coldfield.
Item 11.
You will date करो.
My,
11 sir.
there is an interim order, my lord. Interim order may be.
Yes.
May I please,
One
my lord?
Item 11.
Acharya, one thing since it is in his absence, subject to his presence and any submission.
My lord.
से जहाँ appear कॉलेज यदि राजी हुए अर्जन हबो ना अर्जन हबोनी. That's the short, long and short of the story.
Deeply obliged, my lord.
Yes, yes.
May
My lord,
I have noted your submission and noted the date also.
I please, my lord?
Since
Interim
it's
order.
only 2 days left, so nothing
Interim
will
order
come
is there, my lord.
one day rather.
May I please, my lord?
Yes.
Item
Item
11.
34, my lord. I am for the petitioner, my lord. There is noting they have not filed the death charge, direction was given. So, my lord, it may be,
Make date chart, for me, date chart is not.
My lord.
Pleadings are important.
my lord,
You base your pleadings on whatever you like.
my lord. My lord, they have,
Who is for the other side?
state, my lord. State have to file
You are
the,
Mr. Bokulananda Padi.
my lord.
Date करो तो 34.
So, my lord, I
11.
do apology, my lord. Interim order may continue.
Item 11.
My lord, interim order may be continued. Item 34, interim order may continue. I am for the petitioner. Last occasion, I do.
Yes.
Item 11 on behalf of Mr. Jena. The counter affidavit has been solved today in court, my lord. So we want some time to go through it and file rejoinder if necessary. Let it come after vacation.
You have no power here.
I have filed power, but my name has not been reflected. I have to verify.
Mr. पूरा नाम कौन है?
Sarat Chandra Das.
Das. Name may be indicated. अपना नाम
I-
डेट करो तो आइटम वगैरह.
8 है साहब.
Next item
आखिर साथ
30.
who is for the other side, Mr. Das?
I am for the appealing other side.
You are Mr.
Tarani Prasad Tripathi.
Along with Mr.
Rao.
C. Rao.
Well,
Yes.
My lord, item 30.
30.
Again,
30.
30. I am appearing for petitioner. My lord, pray call for after vacation. And then,
What's your name, madam? What's your name?
Swagatika Ponda. I have no power in this case on behalf of Mr. P.K. Misra.
Date
Well,
करो.
there is
Mr.
an-
Malik, date करो तू.
8 है साहब.
Item 20.
Interim order, my lord.
आपके साथ.
Item 28.
Interim order to
This is
continue.
interim order.
Anywhere interim order is there already, so it will be continue. If not there, it cannot.
Item 28 on Mr. P. After vacation.
You are Mr. Sahoo.
SKNR.
आपका नाम इसके नाम.
Yes, ma'am.
No, sir.
9 सात है.
My lord, 27, my lord.
27.
I am on behalf of opposite party number 2.
Yes.
I have contacted the petitioner advocate.
Remain in contact. कौन चाहूँगी?
After vacation, after vacation.
Date करो.
हाँ.
27.
2 sir.
Who is that?
2 साथ.
Lordship, item number 12.
You have informed Mr. Prashant Kumar Ponda.
No. I am opposite party number 2 bank.
You contact କରୁଛନ୍ତି କାହା
ନା କଣ୍ଟାକ୍ଟ କରିଥିଲି ପ୍ରସାଦ ମୁଁ କଣ୍ଟାକ୍ଟ ଜଷ୍ଟ
ନାଇଁ କହୁଛନ୍ତି.
ନାଇଁ
ଓଡି
Sorry.
ଓଡ଼ିଆରେ କହିଲି.
ସରି
Yes.
Lordship, item number 12. The matter has become infructuous.
So please file a memo. What's your name?
Poonam Acharya on behalf of Advocate S.K. Mohanty.
I am for the opposite party in that matter, Your Lordship.
Please. But Miss Acharya, you don't have authority.
No, I don't
so
have power.
we file a memo signed by the advocate on record.
I'll do it.
Can you do it today, right now?
I'll see.
I mean, by the second half, you can hand it over to the court master.
Okay,
Or else it will be listed tomorrow to be mentioned.
Oh, Lordship, I'll try.
Because by evening also, I mean, they are struggling with the order. Unless you file that memo, order can't be passed.
I'll do it, Lordship.
My lord, in that matter, I am appearing for the opposite
I have
party.
noted this, my lord. I have noted.
My-
Mark your presence.
Obliged, obliged, your lord.
But I'm recording the order, Mr. Acharya. Kindly wait for some time. I'll record the order that you have filed that. Yes.
That's item number 5.
Okay. I sanction पड़ेगा. Right.
Lordship, may pardon me to answer.
This first page the छाड़ दियो तू.
It's a read petition, my lord. Number
Fresh matter.
No, my lord.
How it can be listed in a day? By tomorrow, how can it be listed, Mr.? You want after vacation at a particular date, or you wait and file the memo in the registry? That's your choice.
No, my lord, it may be listed on tomorrow or day after tomorrow as
Sir, day after tomorrow, what is the urgency? Which year? You are not telling even. When I'm asking you whether it's a fresh matter, you have to tell it's after notice, or for what reason you are mentioning. Which year matter?
2018, my lord.
After 7 years, how it can say that it is important?
No,
It's
my
after
lord,
notice.
earlier there was a stay regarding the recruitment of.
So have you filed
TBW.
any IE?
Yes, my lord, I have filed a IE.
Kali order se aano tu?
8350 of 20.
Kone ହେଇପାରିବ ନା ହେଇପାରିବ?
ଅଛି 18/6 ତାର ଆଇରେ ଆସିବ
18 ରେ ଅଛି।
ପୋଷ୍ଟିଂ
ତାହେଲେ ଆପଣ 18 ରେ କେମିତି ପୋଷ୍ଟିଂ ହେଇଛି ଆପଣ ସେତେବେଳେ କହିଲେନି? Whenever you are mentioning, also have the complete comprehension of what you are doing. The matter is already posted to 18/6. How the judicial order will be preponed in absence of the other year? The only possibility for filing a memo for orders is that both of you together file memo. Simply korantuni. You see, there is already a judicial order directing the matter to be listed on 18/6. Today, file a memo. There can't be a judicial order. Verify karantu, other side to consult karantu. Nale ei paribo, nale ei paribo. What is the reason for 18/6 पूर्व आपण काली लिस्ट करिवे चाहुचंती?
My lord, during the recruitment of DBW worker in Hon'Ble Polangi, my lord.
Correct, sir. But it has been posted to 18/6. You are unable to answer that. Buji ke asantu. Still, I am giving you that accommodation that upon though mentioned time will be over now. But buji ki seda kuhantu. Check it. Don't do it this way. And don't get disheartened. You start learning this. This is the process. Mr. Sagat Das.
Yes, my lord. Well, item number 21. I have taken consent from the. Yes, my lord. I have taken consent from the opposite party.
Your lordship.
On this declared. But empty kai babu chandi. Our virtual reality ki विश्वास करना चाहिए. 21.
I am actually the opposite party now 1.
Yes.
I am taking consent for the petitioner counsel by yesterday night. He has no objection.
It is GN Misra. Gopinath.
Yes, my lord.
Acha, sorry.
I am for the opposite panel 2 and 3.
The order will be passed when the matter is called or reaches. आपनकर date करंतु.
9/7.
9/7 will be fine.
Hello, please.
Interim order is there.
No, my lord.
This is after notice matter for hearing.
Yes.
Yes, my lord.
Your lordship, item number 15.
One. Yes.
I am for the opposite party and appearing on behalf of my senior Biranji Narayan Mahanti.
आपनकर नाम
Shweta Senapati, S. Senapati.
I'll record you. Mark his presence.
Your lordship, I have to also make a mention, your lordship.
Please.
Your lordship, there is an admiralty matter in which the vessel was not arrested because it is an Indian vessel. We had filed the suit for the recovery of the dues. However, within the tenure of the lease, we have been dispossessed and someone else has been giving the possession of the vessel. If the vessel leaves the territory of the Odisha jurisdiction, then the matter would become infructuous. For that reason,
So that is a registered international ship or Indian ship?
Indian ship.
Then already you are dispossessed, so the admiralty suit will not be possible for you to get interim order.
Your lordship, there isn't an interim.
So this was mentioned earlier. This question
Yes,
I
your
asked, but nobody could answer this. And there is no urgency as far as tomorrow is concerned. Only way it can be taken up is tomorrow. Tomorrow there is no possibility of having a full day. There is other benches also. So leave it there. I mean, when I hear maybe it's not kind of miss the bus. You missed the ship when it was you were dispossessed.
Your Lordship, we had filed the suit before we were dispossessed.
Post disposition, and it's about 2-3 months back in February you have filed.
Yes, Your Lordship.
My Lord, item number 7. My Lord, item number.
That's it. Kindly mark your colleague in the court. Chalchi, court chalchi. So I don't know how can you take injunction or arrest order, but because after you have been dispossessed.
Your Lordship, because we have legitimate dues against the opposite party.
That you should have taken care of when you filed the suit and moved immediately. You did not move for some.
Your Lordship, we had moved, but the Honorable Court was of the opinion that let the opposite party appear, and at this point, because it's an Indian vessel, the matter wouldn't become infructuous, and it wouldn't leave the
basically,
port.
In fact, somehow you are saying the same thing I was telling you, that if it is in Indian waters, territorial waters, it will go to some other state. There you will have a cause of action to file admiralty.
Indeed, Your Lordship.
So no difficulty there. And here you have already lost that opportunity. That's the problem. With the same set of cause of action, the second suit is barred here. And already, not fairly, factually. Factually, you say that you have been dispossessed. So how any interim order can be passed? I think the only way out is that you have to file another suit, maybe here or maybe other territorial water. Jurisdiction of territorial jurisdiction of any other high court.
High Court.
So take a call.
Indeed, Your Lordship. Much obliged, Your Lordship.
Yes, please. 7 टी wait करिवे ना अपन adjourn कर देवे. Order से.
My Lord, this is a matter of restoration, my Lord. Restoration, my Lord. I am filed CMAPL 861/23. Restoration of WPC number 3,427/23.
Mr. Barik, you wait for your turn. Why you are mentioning now? Out of turn?
Yes, my Lord. Yes, my Lord.
नहीं साथ कॉल करेंगे. एक आरंभ ही नहीं. एक रखिए.
Item 1.
May I please, man? Item 1, my Lordship has directed last occasion to substitute the parties, my Lord.
Mr. S. Satpathy for the petitioner.
Yes,
Mr. Sanjeev Singh, AGA for the state.
Present incumbent is to be intimated who has the present incumbent.
My Lord. As per my instruction, my Lord, the opposite party number 2, new has been joined, my Lord.
So please change.
I will file an IA for substitution.
The Lord Counsel for the petitioner submits that since the matter is pending since as the matter is pending since 2 years, the incumbency of the opposite party officers, opposite parties, incumbency of the opposite parties have changed. He seeks adjournment to bring on record the present incumbents by filing IA. As prayed for Mr. Daisy Chop for orders.
Okay, sir.
Liberty to mention for listing before the assignment. Daisy Rakhantuli. Reopening. Assignment list. You have to make another mention if it is not listed. Or maybe assigned to other bench.
Okay.
Item 2.
Item number 2, kindly after vacation.
Your name, sir?
SK Mohanty.
Mr. SK Mohanty for the petitioner. It has the conversion date of time. Arjun can go to na dokar adjournment dokar. Adjournment dokar. Sabutre adjournment dokar. Mr. Sanjeev Singh, AGA for the state. The Lord Counsel for the petitioner seeks adjournment. As prayed for lister. एक साथ.
Item 3.
3 ना 5 ओर की 3 मेंशन कर. 3 कर दियो तू. कौन करिए? पास ओवर कर दियो फ्रेश में.
Item 4.
Mr. Subhasis Patnaik for the petitioner. Mr. Sanjeev Singh, AGA for the UP number 1.
affidavit में receive कर लेंगे justice हमें order दी वो receive कर लेंगे उसे receive कर लेंगे notice चाहिए
Hey, both ways.
ବହୁତ ମୁଁ ତାହେଲେ ନେଇଯାଉଛି steps
ଆପଣ ତାହେଲେ ମୁଁ order କରିଥିଲି both ways.
ବହୁତ ଯେ ମୁଁ ଜଷ୍ଟିସ ସମୟରେ ନେଇଗଲି କାରଣ ସେ ଜଲ୍ଦି କମ୍ପ୍ଲାଏ ହେଇଯିବ ଆପଣଙ୍କ ଅର୍ଡରଟା ସେ ରିସିଭ୍ କଲେ ମୁଁ
That is the reason.
ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟ ୱିଥ୍ ରେଡିରେ ନେଇଯିବି
এটা কি তার
ବ୍ରାଞ୍ଚ ମ୍ୟାନେଜର ଆଇସିଆଇସିଆଇ ବ୍ୟାଙ୍କ
affidavit has been filed
ପିଟିସନ
by the petitioner indicating that justice summons were refused by the branch manager.
ICICI Bank
Details देखिए दियो.
आइए opposite but note 2
Opposite party number 2. Yes, sir.
To police. No, what he is saying, let it come after vacation. No, say private bank was have a much alike. Thank you for the panel on their advice, they are doing everything. And I say so, say immediately private council man advice नहीं करूँ service I can make it more. Service to
either by himself or by counsels. The Latvian and explain this conduct by the affidavit. Regarding individual who accepts honors by the is
मुझे लगता है
କାଲି ଏବେ ଆସିବେ ଆସିବେ
letters have been mentioned by the Lord for the commission. Communication of the order to the concerned police station of the state police. Department number 2 appears in person. No further necessity. There will be no further necessity of police assuring this presence, ensuring this presence.
This is so much to appear, then not necessary.
It's not a violent offense.
Yes. Yeah.
Same time, I built a modified.
No. A copy of the order may be common.
Or with the review.
After ନା ନା ସେ
ହଁ ମୋ ପାଖରେ କପି ଅଛି ସ୍କାନ୍ ହେଇକି ଥାଏ ସ୍କାନ୍ ହେଇକି ରହିଯାଉ ଏଇ ରିଷ୍ଟ କପି କୋର୍ଟ ରେକର୍ଡ
ଅଛି
ଆଜ୍ଞା ଅଦର ପାର୍ଟ ମୁଁ ସେ ଟୋଟାଲ ରିସିଭ କରନ୍ତି ଆଉ ଖୋଲିବେନି ଆକାଉଣ୍ଟ ବି ଅପରେଟ କରିପାରିବେନି ମୋର ହେଇପାରିଲାନି କିଛି ନହେଲେ ମୁଁ କେମିତି କଣ କରି ଆରେଞ୍ଜମେଣ୍ଟ କରି କଣ କରିବି ଆଉ କଣ କରାଯିବ ଆଜ୍ଞା ମୁଁ ସ୍ପିଡ ପୋଷ୍ଟ ନୋଟିସ ନେଇନି 10 ଟା ନେଇଗଲି ଯେହେତୁ ଶୀଘ୍ର ହେଇଯିବ କହିଲେ ତ ଦେଇଦେବି ପୋଷ୍ଟ ରେଗୁଲେସନ୍ସ ଆଜ୍ଞା 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 in interim it is directed that aging of accounts shall continue except the amount of rupees 52 lakhs 15,332 for furnishing of the bank guarantee acquiring securing certificate demand for the said purpose learned counsel shall obtain instruction regarding total amount claimed to the opposite party number 2 bank which has been frozen. It is also indicated that if any amount more than 50 is there, the petitioner can utilize the said amount of deposit to secure 52 lakhs 15,332 and furnish the bank guarantee before this court. हाँ सीटा ही पर नहीं देखिए गोटे सेकंड आप लोग देखिए हाँ हाँ वो अरेंज कर दे हाँ 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 ଆଜ୍ଞା ମୁଁ ସେଇଟା 16 ଭିତରେ ମୁଁ କହିପାରିବି ଏଇ ପ୍ରିୟ କହିପାରିବି ବୁଝି
that order they to send me pass it na Helen because you are in position to deposit
exactly huh.
On that day this order was lost by proposing this order
exactly
but he said that I cannot deposit because unless I withdraw money I cannot deposit that is why this order was passed if you are ready to deposit this order will be passed
my lord I am my lord your lordship ना सर सीआर पर लिखा है जी
सीआर
पिछले को 800
Item 5.
I am appearing for the petitioner, my lord. Matter can be adjourned to any other date, my lord. I'll file an Nitya Brata Beria on behalf of Nitya.
Oh.
Yes.
Yes.
Any sir.
Much of it.
Item 6. So on the behalf of Mr. Naik, my lord, I filed an IA for amendment of repetition.
I will file one objection to this because needs objection because
10 ବର୍ଷ ହେଇଗଲାଣି
ଆଜ୍ଞା 24 ରେ ଫାଇଲ କରିଛନ୍ତି 10 ବର୍ଷରେ କତ 9 ବର୍ଷ ହେଲା ଠିକ ଅଛି ଏବେ ଫାଇଲ କରିଛନ୍ତି ଆଇଏ when this matter was not entertained my stand was that it has been done in accordance with the bipartite agreement which has the statutory force now if amendment is being sought to challenge that bipartite statement on the ground that it is ultra vires. Completely.
What Mr. Mishra is saying that it changes the nature and character of the
Completely. That is why I want to fail.
You should have. It is only a suggestion, of course. You could have filed a fresh petition along with this petition.
এটা 2005 300
এটা কেতে 12536
of 2024.
12536.
আপনার HP Das.
Ikke Jena, my lord. On the behalf of
Jena. So AK Jena on behalf of KK Naik. So Anindya Kumar Mishra for the opposite party. Lord Counsel for the petitioner submits that IA number 12536 of 2024 has been filed seeking amendment of the pleadings and prayer of the writ petition. The learned counsel for the opposite party submits that he shall file objection to the said IA. So it is further submitted that the proposed IA changes the nature and character of the petition as after filing of counter, the counterfeiling. After filing of counter by the opposite party, taking a stand that the action taken is by the employer. Action taken by the employer is pursuant to the bipartite agreement. In the IA, the said agreement is challenged after 9 years of filing of the writ petition.
And that too ultra vires hobo kimti agreement is that it?
This is regarding retrenchment.
No, this is regarding compassionate appointment.
Compassionate appointment. You are giving them a quantifiable sum or what?
No, we are saying that as per the bipartite agreement, the ladies employees could not have been placed in the live register because of the the nature of the work. So there was monetary compensation for them. He says that this is discriminatory. We said that this is the bipartite statement. So now
the person was working in a coal mines inside.
Yes. I'll file objection.
Mr. Jena, you also consider these things. This is not simply a very legal proposition that whether you challenge, that's one way of looking at it. But other part is that whether the lady can work inside the mines.
This agreement.
There is an agreement between for all. When all the workmen, they have entered into an agreement. You have to consider these aspects. Litigation after 10 years, end of 10 years, and the petitioner has not got anything. Then there is a hope that by amendment something would happen. By challenging an agreement, how many people you have to make parties? They are not the only signatory to that.
Violating Article 14.
Violating Article 14, that's your ground. But the agreement is entered between the parties, say 3-4 persons. You are challenging only the MCL is party. Mr. Mishra representing MCL is the only party. How can you challenge the agreement? And how can you say that agreement has to be equitable and conformity with 14?
Other trade unions are also there.
That I am trying to point them out. Those who are signatories to the agreement. Thus, private contract takes care of Article 14, 16, 21. Workmen working inside mine, they enter into an agreement. This will be the condition. Some of the workmen may agree, may not disagree, but is it possible to evaluate that in touchstone of Article 14? Yes, you did karo. On consent list on 3 साथ है. Yes.
7.
Mr. Barik.
My lord.
Barik for the.
I have filed CMA PL number. For restoration of
Odisha.
For restoration of
Bhubaneswar, addresses arguments.
My lord, I have filed the CMAPL for restoration of WPC number 31,427 which was dismissed for non-prosecution. My lord.
So Sanjeev Swai AGA for the state. Apna copy serve karna the 5D achi defect.
Copy I received.
Achha. The defect number 5D as counted by the registry regarding copy of the CMAPL not being served on state shall be treated to be compliant as the Learned AGA has received copy.
The grounds,
The first line.
only half page petition, the ground taken that the petitioner is ill. So question of petitioner appearing before this Honorable Court is not required. The advocate was not ill.
Better particulars given to Mr. Barik.
My lord.
After filing Wakalatnama, the petitioner suffering of something like today, banks, they have merged, but still the lawyers appear. You understand that? Was the petitioner appearing in person?
No, my lord, the petitioner was not appearing in person, my lord. On the particular.
Can you say that whether petitioner was ill or otherwise? How is it relevant? Better particulars सहित ये करंतु. In fact, I mean, only 3 paragraphs you say that due to illness he could not attend on 23/11/23, and the Learned AGA has to say that there is no petitioner was not required to attend also. Have you seen the petition, Mr. Barik? You look at your petition.
No, lord, my lord, no, I have not seen that petition.
Petition neither.
You have not drafted the petition. Mr. Barik submits that he may be permitted to withdraw the CMAPL to file it with better particulars. Mr. Barik, please take a plausible ground in your petition of CMAPL. How the petitioner's ill health would impact the proceeding before the court when he is not appearing in person.
My lord, on the particular day he was ill, for which he did not appear.
Sir, he was never appearing in person, sir. So Barik, the petitioner was not appearing in person. He engaged his learned counsel to appear.
My lord.
So how can you, that plea will be a good reason for non-appearance, to condone non-appearance? Was it the first date of appearance?
First date of appearance, my lord.
How can it be? You are the petitioner yourself. You filed a petition.
My lord, the second time, my lord, the advocate was ill, my lord. My lord, the advocate was ill, for which he could not conduct the case before the Honorable Court.
We have not said that.
Look at your petition, Mr. Barik. Para 2 पढ़ंतु. CMAPL para 2 पढ़ंतु.
Sir, I have written the petitioner was ill, my lord.
So don't. How can it be changed that the advocate was ill? You file a better petition.
My lord.
After you file that, you can withdraw this. So the delay in filing the CMAPL how much days? 60.
My lord, the filing was not a delay.
30 days. CMAPL 30
days. So you file a petition with better particulars and file make a prayer or memo to file withdraw this.
Yes, my lord.
So by what time you can do it?
My lord, I have filed one petition for a battery.
Sorry, could not hear you.
Today.
Today.
My lord, today I have not filed.
Day after, Order कौन लेके? Particulars. 6 adjournment. If he could have looked at the petition today also, he could have improved it. List on 16 for orders. Yes.
Item A.
Please, Lordships, kindly see the last order. IA number 19 of 2025. The Lordships have directed the Registrar Judicial to.
Yes, he has put up a note that he refers to a Supreme Court decision, and you should have referred that.
So, ADML's 2 of 2022.
Sorry, could not get you.
There is a matter of ADML's 2 of 2022, wherein this honorable court has been pleased to see that if the matter gets settled on
that's
court.
That shows some binding precedent. So if this court had relied on certain decision to say that yes, it can be withdrawn, because you see, it is a monetary thing which is state is collecting. Court fees is state's anxiety to collect fees from a litigant.
Section 16 of the Court Fee Act. That entitles 16 of the Court Fee.
Yes.
Section 16 is refund of fee. As the court refers the parties to sue to anyone to mode of settlement or dispute. Refer to it section 89 of CPC. Plaintiff shall be entitled to a certificate from the court authorizing him to receive back from the collector the full amount paid in respect of such claim.
Collector means this collector is defined.
Collector means collector is not defined here, but the connotation would be to use.
No,
If I'm entitled to a certificate, then I can produce before the.
Those words cannot be added by interpreting collector. We should have thought that what it means to be. You have SEC with you.
So I have.
Now look at 2021 3 SEC 560. (2021) Volume 3 SEC 560. I'm not asking the name because I'm holding it. That answers the proposition you are making actually. If section 89 is different, section 89 is different.
Even court reference.
You were placing which section?
Was placing on section 16.
1-6. Actually, if you look at chapter 3, capital A, next 19A, relief were to a high court. A court fee has been paid. So I think it is a separate chapter also. So that is how this Subramaniam will help.
Tomorrow I'll get that judgment and I'll.
So there is no point in keeping. What's your name?
Pratik Das.
So Pratik Das for the plaintiff. Anyone there for the defendant? Who is there? Dependent blank. By order dated 9/5/2025, after the plaintiff and defendant agreed for out-of-court settlement and the suit was allowed to be withdrawn. Regarding IA number 19 of 2025, filed by the plaintiff, the following was directed. Para 5 hochi sida, para 5 ta kar do. Reproduce kar do. The learned registrar judicial, in response to the said order of this court, has put up a note which reveals the following. Note dated 13/5 आज कितने तारीख 14 13/5 এটা রেকর্ডে রাখিও আসছি ওটা ফাইলে পুট আপ ହେଇକି ହେଲା 13/5 এখন পেজ নেট হবে যেমনি যা করে রাখি দেবে আপনি ঠিক আছে 13/5 put up note dated which on going through the IA number 19 up to refund of the court fees. ଯୋଉଠି ଆପଣ ନୋଟ ରଖାଯାଏ ସେଇଠି ରଖିବେ ଆପଣ ମାନେ ଏଟା ଅଲଗା ଅଛି ହଜେଇବେନି that is the sole proposition. The learned counsel for the petitioner, Mr. Das, refers to section 16 of the Court Fees Act, 1870. 16. The said section is reproduced herein. In the decision rendered by the Supreme Court in High Court of Madras versus M.C. Subramaniam, into bracket 2021, bracket closed, 3 SCC 560. The Supreme Court considered regarding interpretation of section 89 of the Code of Civil Procedure, 1908, as referred to in section 16 of the Court Fees Act. The Supreme Court accepted the interpretation given by the Madras High Court that section 89 of the CPC should be interpreted liberally. Stop. Section 89 provides for settlement of disputes outside the court. As stop. Section 89 is reproduced here. The issue before the Madras High Court and ultimately approved by the Supreme Court is that whether any of the modes of settlement outside court other than specified in section 89 can also come to the aid of the plaintiff to seek refund of the court fee deposited as provided in section 16 of the Court Fees Act, 1970. The Apex Court held that the benefit of section 16 can be extended of refund of court fee. The benefit of refund of court fee, the benefit of refund of court fee can be extended in any kind of settlement of dispute outside the court. Considering the submissions of the counsel for the plaintiff, this court is of the cultured opinion that the plaintiff is entitled for refund of the court fee in terms of section 16 of the Court Fees Act of 1870, read with section 89 of the Civil Procedure Code, 1908, and in view of the decision rendered by the Supreme Court in 2021, in High Court of Madras into bracket Supra. The IA is allowed and disposed of. The petitioner shall move the registry for refund of the court fee in the manner as provided in the rules in the OHC rules, Odisha High Court rules, /CPC and Court Fees Act. The petitioner, after moving the registry shall the registry shall act upon such application of the petitioner and refund the court fees. Ordered accordingly. Yes.
Item 9.
May I please, Your Lordship? Your Lordship.
Yes.
Lordship, here the petitioner, initially there was a demand order issued against the petitioner.
You are Mr. Tibrewal.
Khandelwal, Abhay Khandelwal.
Abhay Khandelwal. Mr. A. Khandelwal. For petitioner, Mr. Amarendra Prasad Rai for the opposite party. Yes, Mr. Khandelwal.
Lordship. Lordship, there was a demand order which was issued against the petitioner under Annexure 2 series, page 35 of the petition.
Opposite parties 1, 2, and 3. Demand. Yes, please carry on.
The said demand order was issued on 8/11/2024.
Yes.
Thereafter, under the same annexure, Your Lordship, under page.
You are referring to which annexure? 8/11/24.
Annexure 2 series, Your Lordship.
Yes.
Thereafter, Your Lordship.
Page 35.
Page 35.
Yes.
Thereafter, Your Lordship, may kindly.
So that's a 45A order.
45A order.
Yes.
The said order was received by the petitioner on dated 7/11/2024, nearly after a month.
Which order, sir? You are referring?
Same.
Because 8/11 is after 7/11. But you are saying
7/12, Your Lordship. Page 38, Your Lordship, may kindly.
So then, no, you made the mistake of saying 7/11.
Lordship.
7/12.
7/12.
Yes.
Page 38, Your Lordship. I have enclosed the postal tracking report. Your Lordship.
Yes, yes.
And after receiving the said order, Your Lordship, the petitioner filed an appeal before the director, ESIC Corporation, Bhubaneswar.
Appeal is statutory.
Statutory. 60
Right,
days.
Right. The appeal is at page.
Page under Annexure 8 series, Your Lordship, page 172.
Yes.
Appeal memo. Appeal applications.
Yes.
Under section 45AA.
Yes.
The said appeal was the appeal which was filed by the petitioner on dated 4/3/2025 under Annexure 9. It was rejected against the petitioner on the ground that it is filed page 183, Your Lordship.
Yes.
Last paragraph, may I read?
Correct. Please carry on. Yes, you submit.
Considering that the appeal has not been made within the prescribed time period, your appeal dated 7/2/2025 is not accepted for hearing under section 45AA of ESI Act and hereby stands rejected.
Yes.
Your Lordship, aggrieved by said order, this order, I have approached this honorable court.
Mr. Rai, you are having the copy of this petition.
Lordship.
You read petition.
Look at page 183.
Yes, madam. Madam, before that.
No.
Yes, madam.
If you before answering anything, you have to address me or what? And you are. I'm asking you to look at.
Provision ta koi dita.
No, provision ta mu jani na pare. Don't either overestimate or not underestimate. And when you are underestimating, don't make it very low.
That I cannot, sir.
So no, you may. You are free to do that. I have no difficulty.
No,
but look at page 183.
I can.
But also don't overestimate the authority. That's the problem. Look at 183. What he has done.
Madam.
Are you getting 183?
Madam.
Yes. Mr. Khandelwal placed the last paragraph. Read slowly the paragraph above that. But it reads the appeal. And
but the appeal dated 7/2/25 has not been made within the time limit of 60 days from the receipt of.
Stop there. What he writes. Just read what he writes. From the receipt of, so he fails his own logic. He puts up a logic. 60 days from receipt. Next line. Sir, just read the next slide.
From the receipt of original 45A order dated 8/11.
That is fine. Rest is immaterial. For legal consideration, rest date. But read the second line. The second paragraph. There he fails.
It is stated.
Considering, no. Read completely. Then you will understand how he's approaching it.
It is stated.
Considering. You are reading the paragraph above. I am asking you to read it continuously. What Mr. Khandelwal only placed the last paragraph.
Considering considering that the appeal has not been made within the prescribed time period.
Stop there. It doesn't refer to any date. What he thinks to be the prescribed time period, from which date, whether it was the date of receipt. Mr. Tripathi, did you assist him?
Yes.
You assisted this appellate authority?
No.
Then why you are assisting Mr. Rai? I understand. You did not. Because he gets confused. When the court is discussing something with a lawyer and you start something briefing him.
Sorry.
No, it's not a question of sorry. I'm saying it's a question of approach. Because it is a simple bare minimum facts. So the assistance for the
He should have put the date of order and
so how can he overcome that? He knows it. He knows it that it has to be within 60 days from the date of receipt. Now you come to the provision. Yes.
My lord, the provision is.
Yes, I act.
Yes, my lord. Section 45AA.
That he has referred.
Section 45AA. If an employer is not satisfied with the order referred to in section 45A, he may prefer an appeal to an appellate authority as may be provided by regulation within 60 days of the date of such order after depositing 25% of the contribution so ordered or the contribution as per his own calculation, whichever is higher with the corporation.
How does it help you?
My lord?
How does it help you?
My lord?
Where does this 45A, but why you are reading 45A? Because he has also referred, the appellate authority has referred. So by reading that, how does it help you? What is the interpretation put out by you that it will help such an action?
My lord, the provision was is 60 days from the order, date of order. But here, the order was communicated.
What you are missing, Mr. Rai? What you are missing in the Rai while reading 45A? You are adding irrespective of it being communicated. Why do you find that irrespective of communication? "60 days from the order," you are reading it as if irrespective of it being communicated or not. Where is that?
No, there is no such.
So then how can anyone presume that I mean it is communicated or otherwise? Unless you, because whenever there is a limitation provided, limitation actually takes away, creates a right and takes away a right also. So it has to be interpreted at least to the extent that from the date of knowledge.
My lord.
It has to be. That's no, that can't be. So if you pass a order, keep it with you, give it to Mr. Tripathi or Mr. Ray. Is it sufficient?
No, ma'am.
Then
for which the
so you have to, so he has to give that finding that it was communicated or it was not communicated or it was within the knowledge. Nothing.
My lord, he has not reflected that portion.
In fact, he gives it and he fails it. In the last one paragraph, he refers to 45A, and the concluding paragraph, he doesn't refer to give anything. What is his perception?
My lord, I am understanding what my lord is saying. But the authority...
for you, see, for you will be a much better appellate authority being a student of law. Me being a student of law, I will be a much better appellate authority to understand these things.
My lord.
I will not add or you will not add these things that irrespective of date of communication, irrespective of knowledge, it's a strictest and unreasonable interpretation also. Can be possible for law. I mean, for the sake of argument, you can argue that. Where the statute is contemplating that.
There is no
contemplation. No contemplation.
For which I have
and appellate authority, I have been asking this question, both you and Mr. Misra and other learned counsel, they have been saying that since there is principle of natural justice violation, appeal is to be entertained. Writ is entertained.
But here is the question.
But he has proved the authority.
On that,
you obtain instruction, but you have to be concerned with this aspect. I mean, you have to take instruction in this aspect, that whether he is considering 45A in its true perspective, proper perspective, or simply is giving one line that
I have brought two decisions in which the honorable judges of Kerala High Court and
get some Supreme Court decision. It's a central act.
Following the decision of Honorable Supreme
Court.
So
you study that Supreme Court decision and make your submission. If you want.
They say once the limitation period is over, the appellate authority has no power to enter.
That is a subsequent decision. That is a subsequent event. That is a subsequent event. That is or enlargement of limitation period. Go through Hon'Ble Indian the sales tax matter. That is that is what you are seeing. That is not the decision on this point.
No, is that at this point?
Show me. And find out some Supreme Court decision that you see what you are saying is ridiculous. Who has got the power to condone the delay?
And that apart, my lord.
No. Please answer. If you are discussing something that so some High Court has said that they cannot consider after the 60 days.
My lord.
So have they considered the interpretation of 45A? I have not. I'll go through and point you out that what you should read.
And their finding is the petitioner is not
You have read it well, but let me read also. I have not read it.
Sorry.
EIC, you see judge. The code doesn't discuss anything. You read 3 to 6 where it discusses this point. Paragraph 3 to 6. You are saying exactly on the point where you are getting this. Read it aloud, sir, so that para 3 to padhuntu.
The Lord and Senior Counsel submitted that though the appeal was filed beyond the period of limitation, the third respondent being a quasi-judicial authority had the power to condone the delay.
So so now stop there for a moment. Why does it say that whether the order was communicated on which they communicated? Because 60 days from the date of communication of the order or not, that is the issue he is arguing.
My lord.
So you have to find a decision on that.
My lord.
That is not the date of communication, it is the date of passing of order, whether communicated or not.
My lord.
You can argue that. Though it is
and as per the direction
then you read further also. Then read further. Nowhere it is discussing whether it is communicated or not.
No, my lord. I am submitting as per direction of the Honorable Coordinate Bench. The instruction was supplied by the authority.
Sir, you bring it on record, serve it on him. Don't convert this proceeding to be one way. Apano jaha kagaz debe mu rakhibi tapare tanku apano jota if you want to make a serious submission, bring it on record by affidavit. But definitely refer to that. Apano kon koya ku chahunchandi kuhuntu. But don't hand it over without serving a copy. Kon chahunchandi kuhuntu. What is the point you are trying to make?
They have, what my lord asking, they have pointed out the order was passed on such and such date, communicated on such and such date, and the receipt of the order was from such and such date, and by that process.
In this case, by that process,
62 days was delay in filing the appeal. 2 days. Was delay in filing the appeal, and the authority has no power to condone the delay. So appeal was dismissed.
In this case or other case?
No. In the particular case.
2 days delay.
My lord.
Yes.
Admittedly, my lord, there is a 2-day delay. But what I am pointing out to my lord is that this order has been passed without giving me any opportunity to explain the delay. And for that,
they are relying on. There is Supreme Court decision. One is that Hon'Ble India. Statutory provision giving that period. So the 75 is the 75 you concede.
My lord.
So you take a call on this.
Lordship,
and there is
I am not disposing it of today.
Lordship.
So you have heard your learned. So you should have said that it is 2 days delay.
Lordship.
And Mr. Ray, the first point you should have argued that even calculating the date of communication, it is 2 days delay. You are not saying, you are saying everything. We have gone to Kerala also. Kerala,
sorry.
Where have you gone? Kerala and Tamil Nadu?
No. One Kerala and one in Madhya Pradesh.
So you have traveled throughout India. But here you are standing, you are not saying that 2 days delay. 1 day delay or 1 day delay is enough. 1 day delay is a delay. But now the question is whether. So they consider that yes, it was communicated and date of communication is to be calculated. He has obtained instruction.
Lordship.
And there is a delay of 2 days.
Your lordship,
Sorry?
To that effect, your lordship, what?
So for that you have to whether the authority, statutory authority has the power to condone the delay.
Lordship.
There is some jurisprudence on that. Case law. There is case law regarding statutory, I mean, this taxing statute, sales tax or value added tax. You examine that. Don't make one lecture. Number item? 9. Mr. Khandelwal for the petitioner, Mr. Abhay Khandelwal.
Lordship.
For the petitioner, Mr. A.P. Rai for the opposite party. Is submitted by the learned counsel for the petitioner that the order passed by the authority, page,
Lordship.
under section 45 capital A of the ESI Act
35,
1948.
Page 35.
Is 35 declared. By the authority, assistant director. By the authority, assistant director into bracket revenue, REV, not revenue, into bracket REV dash Roman 3. 8/11/2024. Raising a demand of rupees
18 lakhs.
Rupees 18,73,872. Was received by the petitioner, who is the employer.
Employer, Your Lordship.
You are not disputing that you are the employer.
No, I'm not.
You have referred to that postal tracking?
Yes,
page?
yes, page 38, received on 7/12/2024.
Sentence was received employer on 7/12/2024 at 17:46 hours, as would be evident from the track consignment of India Post, through which the said order was communicated. The order under section 45-A was challenged before the appellate authority, that is Regional Director, ESI Corporation, Bhubaneswar, by filing appeal on 6th of February 2025. The petitioner is agreed by the order dated 4/3/2025, passed by the appellate authority, which page 183, which discloses the following. Quote, for the appeal dated 07/02/2025 up to stands rejected. Data para last 3 line achieve. Issue notice along with this order. The Purvur submission linked to it is submitted by the learned counsel for the petitioner. Issue notice Purvur. That the petitioner was given an opportunity before his appeal was rejected. There has been violation of the principles of natural justice, as the petitioner has not been allowed to explain the delay of 2 days in filing the appeal. List first time.
10/4/2025. A notice issue any, there was direction issued to my learned senior.
Kindly see,
Mr. Tapare issue notice kar dele. Tapare lekhi diyantu. Mr. Amarendra Prasad Ray, learned counsel, who usually appears for the corporation, so was present on 10/4/2025 and directed by the coordinate bench to obtain instruction. And again the matter was adjourned on 16/4/2025 and 22/4/2025. So, Mr. Ray Was entered appearance by filing Wakratnama?
My lord.
Was entered appearance on behalf of the opposite parties?
21 25.
ठीक है already recorded अच्छी है अपन कौन like Mr. Ray was entered appearance submits that he has obtained instruction that there is delay of 2 days in filing the appeal. It's a decision that he relies on decisions of High Court at Madhya Pradesh. अरे अलग अलग अच्छी अलग अलग डिसीजन कौन के जाने मध्य प्रदेश decision rendered by single bench High Court of Madhya Pradesh at Indore. Relying on an earlier decision. That Limitation Act is applicable. Sentence account लिखिए. Madhya Pradesh in so and so party nada लिखिए and तापर काटी लिखो तो and High Court of Kerala at Ernakulam, also by learned single judge in so and so disposed of so and so. कौन पकड़े कॉपी अच्छी तो ठीक है डिस्टेंस एडिशन दे दे अपन ताको देचुन रेफरेंस है
No, yellow.
ना दे दे
अपन नहीं जिबे दैट टाइप फिल पर अपन यू कैन टेक दिस एक्चुअली फिर देवे गेट इट टू द अपन कौन लिख it is submitted that since the statutory oblique quasi judicial authority under section 45AA cannot condone the delay, the appeal could not have been heard on merits. It is further submitted that the petitioner has efficacious remedy as provided in section 75 of the ESI Act. That is, he can approach the employees insurance court by filing a petition
application.
Filing application.
My lord, language is application.
The learned counsel, Mr. Hon'Ble 6 has time to respond. When do you want, Mr. Hon'Ble?
Lordship, any
Before
date
or after vacation?
After vacation.
Please give a date. Concern Mr. Ray.
My lord,
I have no difficulty, but it is better if you say, because so that it can be. सात 25. Disturb 7/25 on consent. Disturb 7/25.
Lordship, I filed an IA.
IA for what?
IA for stay of the operation of the.
IA 5467 of 2025. Should I agree nothing like? For a file call.
No, that's agree.
So what happened? Why it was not pressed before the coordinate bench?
Lordship, actually, the Honorable Court directed my learned senior to obtain instruction whether any opportunity has been given to me before rejecting my application. For that, your Lordship. Oh, it is reflected in order.
In response to the order dated 10/4/2025 passed by the coordinate bench, Mr. Ray submits that in fact no opportunity was granted to the petitioner before the appeal was rejected on ground of delay.
My lord.
So, however, it is further submitted. The passage, the appellate authority having no power to condone the delay.
Right.
Opportunity would not have inured to the benefit of opportunity of hearing.
Right.
Opportunity of hearing would not have inured to the benefit of the petitioner. The commission has in short आइए लिखंतु IA 5467 of 2025 issue notice as above. Mr. Ray, learned counsel, having already appeared in the writ petition, accepts notice. Copy of the IA has been served.
My lord.
Copy of the IA has been served on Mr. Ray for the opposite parties. As an interim measure, it is directed that operation of the impugned order, impugned appellate order dated 4/3/2025 and the order under 45A 8/11/2024 shall remain stayed till shall remain stayed till in the next date of hearing.
My lord.
I think, Mr. Tibrel, you are doing those sales tax matters or not? Yes. So why you have not noticed Hon'Ble India?
Before the coordinate bench was different. The coordinate bench proceeded with the fact that if the natural justice has not been complied, it will remand back the matter. That all that like the hearing was going on, Your Lordship.
No, correct. By at times, opportunity would become a empty formality.
Empty formality, yes, Lordship. For that we have a
Because you are showing the cause of delay to a court which it cannot entertain.
Lordship, we were relying
Statutory.
on the Madhya Pradesh High Court.
Supreme Court. Get some Supreme Court decision on this.
We also cited Supreme Court judgment, Your Lordship. It's stated.
Where 45A and 45AA.
Your Lordship, that issue.
Then there's no point. Because either you succeed or fail.
Lordship.
Because now also you do not show that because you cannot show here in a writ petition that whether this court can condone. Or you can say alternative argument would be the writ court being a supervisory court, exercise powers 226 powers and condone the delay.
The Madhya Pradesh High Court has said that if the delay is not condoned, the appeal provision will become illusionary. On that it has remanded back the matter. We were relying on that judgment, Your Lordship.
No, same Madhya Pradesh High Court, two decisions he has cited.
We were citing a judgment of coordinate bench, Your Lordship.
Whether 45AA, the period prescribed can be enlarged by the authority itself.
That we have
The appellate court exercising power is a different thing. Writ court definitely can condone, but that is not your argument even.
We can analyze that.
So you have to think in those lines.
We'll analyze that.
And Mr. Ray, so you also please consider this, that whether the writ court can enlarge the 2-day condone the delay and remand it. It can. But in the context of statutory authority 45AA, whether the writ court can. We are happy, at least I am also very happy to exercise my power, but I must know the limitations. That is the request for you to all three of you. Hon'Ble, Tibrewal and Ray. It is time here. Apna dictation aaj nebeni.
Item 10.
Last occasion,
Yes,
directed the opposite party
to get instruction.
There is a problem, my lord. Unless the scale of page revised, how they will supply? That has not been revised.
So that is how you have to obtain instruction. You want court to revise. Court doesn't have any power to revise.
How they can assess without revise the scale?
Whatever, you don't ask these questions to me. These questions you have to discuss with them. If they are thinking that court will revise it, then obviously the answer would be no. While discussing with your client, certain questions can you ask to the court what the court will do? You take a decision wrong or right, court can review it
We
judicially.
have already assessed.
So they kindly refer to read the order dated 23/4/25. You are having copy.
No.
Then how could you discuss with your client also? Unless you are having copy of the order dated 23/4.
Yes, I have supplied.
You have supplied.
Yes, ma'am.
And copy you have not written.
Yes.
ପଢୁନାହାନ୍ତି no କହୁଛନ୍ତି. That screen is available, Mr. Pradhan. ଆପଣଙ୍କ left ରେ ଅଛି, right ରେ ଅଛି. You utilize that facility.
Honorable counsel for the bank shall also obtain instruction calculating the amount of gratuity and EI.
No, you can read from para 3.
Yes, ma'am. Counsel for the appearing for the opposite parties bank submits that it would evident from the counter unnecessary the petition filed representation for calculation of this dues towards GPF and leave salary. After notices are issued, the said amount has been calculated. Calculation sheet has annexed to the writ petition. The alternative prayer of the petitioner is to settle the claim of the petitioner after deducting the amount outstanding against the petitioner at the time of the retirement of the gratuity and aerial leave salary. Learned counsel refers to the order dated 29/6/96, which contains the terms and conditions of the advance sanction to be deceased petitioner. He refers to a paragraph 8, which is reproduced here in below. The bank is at liberty to adjust the gratuity and other emoluments like bonus received from the bank towards unreceived portion of the advance in case of employee resigns, retired premature, or removed from the service of the bank. On the face of it, since the employer did not resign, did not retire prematurely, nor removed from the service, therefore the employer bank cannot fall back upon the said paragraph 8 of that order. However, submitted by the learned counsel for the opposite party cooperative bank was entitled to recover the amount of advance and any other dues towards the employer by following due process of law. In such view of the matter, the bank can pay differential amount as has been paid in the writ petition by deducting the amount due from the calculated amount towards the gratuity and enhancement.
Then the next verse of para.
Honorable counsel for the bank shall also obtain instruction calculating the amount of gratuity and EI by refixing the payoff with effect from 1/4/2001 in terms of order dated 3/5/2002 issued by the registered cooperative societies.
Yes. So how the court comes into picture? The registered cooperative societies issued order dated.
That is not the case here. They are neither
No,
the
that is the
amount
same
nor
case here.
after any prayer.
No, they have.
No, they have not about here in the writ petition.
3/5/2002 it is there.
No.
memo we have filed.
How can I guess it? I don't understand. Upon no kahle kon mu uta manu bhabi likhli na kon. It was part of record. You have not received that. You have not received.
No. Neither in the
ଏମିତି କଲେ କେମିତି ହବ? ତାହେଲେ କଣ ପଢିବାକୁ ଅପୋଜିଟ୍ ପାର୍ଟି କରିବାକୁ ପଡିବ ନା କଣ? ପଢିବା ସାର୍ ଯାହା ଆର୍ଗ୍ୟୁ କରିବେ, ଯାହା ରିସିଭ୍ କରିବେ, ଆପଣ ନୂଆ କଥା କହିବେ, ନୂଆ କଥା ରିସିଭ୍ କରିବେ. And on that day you should have said that I don't have a copy.
No, there is not averment in this.
No sir, ଆପଣ averment ନାହିଁ ବୋଲି କଣ ମାନେ ଭାରି ବଡ କଥା ଡିସ୍କଭର କଲେ ନା କଣ? ନାଇଁ ଆପଣ ଏମିତି ଦୟା କରନ୍ତୁନି କୋର୍ଟ ଉପରେ. ଆପଣ ଦୟା କରନ୍ତୁନି. I will say that you are saying that Corda I have not received.
No, I have not saying. I am not saying.
So let him appear in person. Registration ଦଉଛି ଆପଣ.
I am not saying this.
You can when I replay this, what you are saying, you will realize. You are saying that we do not know that is no averment. That day also you said the same thing.
Yes,
then that day she said that I have filed with a memo. Today she says that I have filed with a memo. Then what the court will do? Court will go and verify in your memo.
No. If they have not made averment here, if my lord can.
Sir, you are not. Don't think the court underestimate the court. Understand. Not about 50 thara कहले कौन improve करिवो. The submission is that we have filed it with a memo and it has to be refixed or directed. It has to be refixed directed by the registrar. Then you have to decide what to do. Because then they will then the third counsel will come, say that it is not on record. Now he will recuse. You should have filed it with affidavit.
I'll file it.
The learned counsel for the opposite party bank submits that you have written instruction or oral.
Oral.
He has discussed certain things orally. He has have you communicated the order?
Yes, ma'am.
He has communicated the order dated 23/4/2025 as available in the official website. The opposite parties have asked certain questions to him, which he also raises in this court. Stuff. The instructions being oral, the court cannot take note of the said instructions as far as the discussions of Mr. S.K. Pradhan with the opposite parties 2 to 4 as suggested. It is submitted that the averment regarding fixation of salary is not made in the writ petition. The learned counsel for the petitioner submits that the order dated 3/5/2002 regarding fixation of salary passed by the Registrar of Cooperative Societies, which is part of the record, is part of the record. ওটা কি ফাইল করলে মেমোরে
35/2000
35
2012 twice it is filed. One is 13/10/2005
once filed on 13/10/2005 and again on
13/12/2005
and again on 13/12/2005. Mr. Parida, the learned counsel who had appeared then, has received the copies of the said memo. Order dated?
Not order dated.
The order dated 13/12/2005. Passed by the coordinate bench. Reflects the submissions of submission of Mrs. Mahanti. Quote kar debe. The said order is reproduced herein. Learned counsel for the petitioner has filed a memo today, literal due so and so up to put of the matter in the month of February 2006. After 20 years of passing the order dated 13/12/2005, the learned counsel for the opposite parties pleads ignorance. In view of the fact that the opposite parties 2 to 4 have obtained a change. What is your response to 13/12/2005 order? order. So, Pradhan, it is so easy to say all these things and find to get the answer is so difficult.
Fine.
See, Mr. Mahanti, if you can scroll it. Order number 3. You have lost your speech after reading the Justice Mahapatra's order.
I am not saying. Then
What is this, Mr. And perhaps she is also very muted. She is not that vociferous. She is not referring to any order. कौन लिख रहा? In the learned counsel, Mr. Pradhan, having gone through the order dated 13/12/2005 passed by the earlier bench, submits that he has not seen the order as he was not appearing. Since Mahanti Learned Counsel submits that yes, that Mr. Pradhan, I cannot direct also to file it because already the coordinate bench has accepted that memo. How can I also say that when accede to your prayer the way you are asking questions and saying that I do not know, it is not on record? Has that order been modified? Justice Mahapatra's order.
At the time, I was not. I was.
Sir, that you have said, sir. I am not saying that you are there and you are denying. I have recorded that also. I believe you that perhaps it was not on record. But I was thinking that you are correct, that you did not, it was not on record, so you could not get instruction. The order dated 13/12/2005 clearly reflect, as quoted above, clearly reflects that the Lord Counsel for the opposite parties was served with the copy of the memo, and the Lord Counsel then appearing sought for time to obtain instruction. The Lord Counsel for the opposite parties now appearing, Mr. Pradhan is requested to obtain instruction in terms of the order dated 13/12/2005 passed by the coordinate bench as undertaken. On consent list on ଗୋଟେ date କରିଦିଅ 30/6 ରେ ଆସିବ ଆପଣ ଦେଖନ୍ତୁ ଯାହା କରିବେ।
Item 12. Lordship, I'll get them.
English are memo day.
Submitted by the starter. Yeah, Google on side on behalf of the state Mahavi Governor. The public was operating party. Running down for the petitioner submits that the petitioner doesn't want to.
It has become infructuous.
Petitioner doesn't want to prosecute any cause. So to that effect, sisters have filed the learned office have filed a memo. Memorandum. This law, this Mr. Chauta, March to be
But today is 14.
In fact, yes. But not very regarding the advance of the I will now whatever matters have been answered, those will be taken up, orders will be passed for adjournment. Any other adjournment you can submit.
Item number 16, madam.
16.
Mr. Roth, the Lawrence Senior Counsel is there. Dismissal matter bank. I'm for the bank, madam. Mr. Roth is also here, my lord. Let me come after vacation.
एक के साथ
My lord, item
Yes.
item
Date
and also item number
Item
18
for the copy of the
13.
order रखा है communicate कर देंगे
I have a small matter. Failing retired person, pensionary benefit. Launch for it.
Which item?
Item number 5.
My lord, I am for the item number 18 on behalf of Ms. S. Patnaik.
The person is not dealing on date. He is calling the district condition. Otherwise, I am sort of mentioned.
Suma Patnaik or Suman Patnaik?
Shivam Mr. I am for the on behalf of Somalin Patnaik.
You have marked your learned senior mentioning urgency. Can she appear today?
No, your lordship. He is
Date कर दियो तो Mr. Roth. Okay, suggested date.
after
vacation,
vacation.
put a date
After
for-
vacation.
36.
Yes,
You are Mr. Shubham Misra.
I am
Shibam.
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 SHIBM. your lordship.
An understanding that they will not further.
No, I'll record your contention. I think earlier ones also have recorded your contention that this is urgent matter.
Otherwise, I would not have.
Yes.
It is item 13.
Yes.
Item 13, my lord.
1-3.
Yes, my lord. Item 13, my lord. After vacation, my lord, I will file affidavit enclosing the legal aid certificate.
automatic one.
Mr. Vibhendra Das.
My lord, Mr. Das was here.
Vibhendra Das was here.
Yes, my lord. he was.
So I am marking his presence.
Yes, my lord.
Date करो
I have also informed you.
Any sir.
तीन साथ है.
My
Yes.
My lord, item 17, Mr. Vibhendra Das was here.
Yes.
He informed me that he will seek time to file the counter affidavit.
Okay. Date. Any suggestion regarding date?
Date
Virtually.
in July range.
कर दियो
11 sir.
I am for the petitioner. My
Yes,
lord.
yes, I have noted. I have marked that. 11 से 25.
Interim orders to continue.
Yes.
Item 31.
Mr. Mohanty's name is to be mentioned, senior, you are
Only my name.
Item 31.
So this counter, additional counter is after post amendment.
Post amendment after the
It has
consolidation.
been allowed. Yes.
Item number 31.
3-1. Yes.
Interim orders to continue in that.
Entry body. Yes. Mark.
And after vacation.
Your name, sir?
Govind Chandra Rai, GC Rai.
31 date करो तो
207.
207.
Obliged.
Item 23, Lordship.
Yes.
In this case, I am for the opposite party.
Yes.
Your Lordship has directed me to
ICR पे आपण yes होता.
Lordship. There is a compromise going on.
सत्यव्रत महांती करो associate क्यों थिले मैडम?
My
This is there. आपण को नाटा मैडम? अर्पिता विश्वाल. A विश्वाल.
So there is a compromise going on.
Mrs. A विश्वाल. So after vacation, what a concern?
Lordship,
Shall I record that you are making an effort to compromise? I mean, amicably settle the matter.
Lordship.
Yeah, unless you keep consent,
I
how
have
can I
talked with Mr. Mohanty, Lordship, my senior. So let it
Date करो तो date करो.
14/7.
14/7 है.
I'll take it delegate.
अच्छा. Last week को पढ़ा तू.
28/7.
Lordship.
Yes, next.
Deeply obliged.
Thank you.
Lords, my lord, I am pardon, my lords.
Yes. 3739.
Can it be taken away? Because I have filed an application. I mentioned your lordship keep
Let
it
us
to
see.
today.
Let us see. I'll come back after recess. I'll be there.
Yes, ma'am. Yes,
Yes.
ma'am. Otherwise, tomorrow, my lords.
Let us see.
Again.
କଲ୍ କରନ୍ତୁ ମେଡିସିନ ଗୁଡାକ କରିଦିଅନ୍ତୁ।
That's over item 3.
None appears for the petitioner, none. Mr. Sanjeev Swai, AGA for the state. None appears for the petitioner, though the matter is called twice over. Once, when it is, and again, after resumption of the proceeding of the court, post lunch. This term, 3/7/2025.
Item 11.
ସେଟା ଆପଣ ତ କରିଲେ ହିଁ ଲଞ୍ଚ ବ୍ରେକ୍ ନିଆ ସରିଯିବ ତ ପଠାନ୍ତୁ ନାହାନ୍ତି ଠିକ ଅଛି ମୁଁ
Item 11,
Mr. S.C. Das on behalf of S.N. Jena. The S.C. Das on behalf of S.N. Jena for the petitioner. Mr. T.P. Tripathi, P. Tripathi on behalf of C. Ananda Rao, Senior Advocate. It is submitted by Mr. Das that though he has filed Wakalatnama, his name is not reflected in the cause list. Stop. Registry shall verify. Stop. If Wakalatnama is on record, name of Mr. Das be indicated in the case brief as well as the cause list. It is submitted by Mr. Das that he has received copy of the counter filed on behalf of the opposite parties in court today. Stop. He may be accommodated to obtain instruction and file rejoinder on behalf of the petitioner. On consent list on 8/7/25.
item 13,
Mr. S.P. Jena for the petitioner. Mr. Vibhudendra Das for the opposite party. Mr. Das, you have filed Wakalat for the
Yes, sir.
Tata Power.
Yes, sir.
It is submitted by Mr. Jena for the petitioner that he shall obtain instruction regarding the substitution of legal heirs of the petitioner and file appropriate petition on consent list on SAP.
14,
Mr. Subhranshu Bhushan Mohanty for the petitioner. Sorry, Mr. Monomoy Basu.
Transfer.
Mr. Monomoy Basu for the petitioner. Mr. Maharana. तो महाराणा पूरा नाम क्या
Biswajit.
B Maharana, B. Maharana for the
Senior panel
counsel. Biswajit Maharana, senior panel counsel for the opposite party, Union of India. On consent list on 7/7/2025.
15,
ठीक है रोल छोटे से. The name of Mr. Subhranshu Bhushan Mohanty and associates shall be deleted from the cause list as well as the case brief, as the petitioner has obtained change. Yes.
15,
Mr. P.S. Acharya for petitioner. Ms. Sweta Senapati for on behalf of B.N. Mohanty for the opposite party. On consent list on 11/7/2025. Interim order passed earlier shall continue till the next date of hearing. Interim order verify करते हैं. Yes.
16,
Mr. Prafullo Kumar Ratha instructed along with Mr. A. Behra for the petitioner. So P.K. Mahapatra for the opposite party. On consent list on 1/7/2025.
17, yes, I
get.
I create time.
Yes, yes. Mr. I. Acharya, I.A. Acharya, Ipsi Taravinda Acharya, I.A. Acharya for the petitioner. Mr. Vibhudendra Das for the opposite party. On consent list on 11/7/2025. Mr. Das submits that Mr. Das for the opposite party submits that he will file the counter on behalf of the opposite parties. interim order dated so and so shall continue till the next date of hearing.
Eighteen.
Mr. Prafulla Kumar Ratha, Senior Advocate, assisted by Mr. A. Behra. For the petitioner, Mr. Shivam Misra, Mr. S. Misra, on behalf of Somalin Patnaik for the opposite party. The learned senior counsel appearing for the petitioner submits that the hearing may be expedited as the matter is pending since 8 years and the petitioner has attained the age of superannuation. The learned counsel for the opposite party, Mr. Misra, submits that in absence of Mrs. Patnaik, the matter may be adjourned. Mr. Rathal and a senior counsel submits that the petitioner is aged about 74 years and the matter be heard. On consent, list on 36/2025. When efforts shall be made for finally hearing the matter.
Nineteen.
The Kalyan Patnaik for the petitioner, Ms. S. Das, Soumi Das, EAS, Das on behalf of S.K. Nanda for the opposite party. Learned counsel for the petitioner submits that the opposite party bank has been merged with other banks and Odisha Gramin Bank is the new entity succeeding the opposite party. He submits that the matter be adjourned. He will file appropriate IA to bring on record the new entity. The counsel for the opposite party submits that they have instructions to appear on behalf of the new entity, that is Odisha Gramin Bank, and shall file their Wakalatnama by the next date. On consent, list on 3/7/2025.
Item 20.
Mr. P.K. Behra for the petitioner, Mr. Ambika Prasad Misra for the opposite party. On consent, list on 10/7/2025.
21.
20 sub-item the same matter. Same कर देंगे, but in view of the order passed with connected WPC numbers 27360/2017. List on consent, list on 10/7/25.
Item 21.
Mr. G.N. Misra for the petitioner, Mr. Saugat Das for the opposite party.
Opposite party number 1.
OP number 1.
2 and 3 pairs.
One, Mr. Devaraj Mahanti for OP number 2 and 3. Mr. Saugat Das being present at the virtual court, High Court of Orissa at Pune, mentions the matter for adjournment. On consent list on 9/7/2025.
Twenty-two,
Mr. S.N. Ponda for the petitioner. Ms. Soumi Das on behalf of S.K. Nanda for the opposite party. The Learned Counsel for the petitioner submits that IA 7867 of 2025 has been filed for amendment of the petition to bring on record Odisha Gramin Bank, which is the new entity, as the opposite party. Odisha Gramin Bank has been merged with some other banks. The IAB listed on the next date. Learned Counsel, Mr. Ms. Das, submits that they have instructions to appear. They know Mr. S.K. Nanda. S.K. Nanda has instructions to appear on behalf of the new entity, Odisha Gramin Bank, and file his Wakalatnama by the next date. On consent list on 2/7/2025. Yes. List for orders.
23,
Mrs. A. Biswal for the Biswal on behalf of S. Mahanti for the petitioner. Mr. S. Rutta, S. Rutta for the opposite party. Is submitted by the Learned Counsel for the appealing parties that there is possibility of settlement out of court between the parties. On consent list on 28/7/2025. I have marked your presence in your matter. You have mentioned. Yes, already.
Okay.
That matter has been already called over. Order has been passed. Yes. Sub item, same order kar diya. Same order. Same appearance. Sorry.
24,
Sub item in view of the order passed in so consent list on. Shorthand khata aniki diyantu. जो अच्छी पेज कॉल करो कनेक्टेड लिखो टू 14501 जो अपन आइटम 23 दिन order passed in the connected WPC number 14300 of 2018 list on offices at the purchase. And 24 Sukanti Biswal. Sorry, this is M.R. Mahapatra on behalf of along with Mr. U.K. Samal for the petitioner. 24 Mr. Pradhan, you are appearing. For one. The additional standing counsel for the OP number 1. The Samir Misra, senior advocate, along with Mr. C.S. Padi for the opposite party. 213. Consent list on 9/7/2025. पूरा interim order गुड़ा को एंट्री बड़ जोड़ा का नोट करछन्ती कि दे देबे यस
24 sub item.
Sub item same in view of the order passed in the connected WPC 15120 2019 list on loss are
25.
So Vikram Senapati for the petitioner. So KC Kanungo for the opposite party. It will same as 19. Change लिख पारिबे तो I call to that people. Yes, Ukilavana change kari. Mr. Kanungo submits that, you may treat it. Senapati submits that, then connected likhibe, in view of the order passed in the connected WPC number 19736 of 2019, list on Arte Sate Kodia purchase. Connected 3 matters. Yes.
Item 26.
Petitioner, retired helper my lord, retired since 2015. Its initial service my lord being excluded, so that I am getting proportionate pension for the regular service, my lord, the 20 years. So as per the new revised structure, pension structure, after addition of 5 years, so that I will get full pension. 25 years required for to to make eligible the employee to get full pension. So my earlier
after it has been made 20 years, there has been no amendment by the opposite party. Now it is 20 years. For full pension, I think it is 20 years.
କିନ୍ତୁ ଆମ ରିଟାୟାରମେଣ୍ଟ 15 16 ପରେ ହେଲା 20.
I understand that. But for that full pension, I think it is made retroactive. Calculation has to be from the date notified. If someone has retired, then it would be calculated. If it is already 20 years, then he has to get pension. But I don't know about this is Tata Power.
Tata Power, they are adopting OCS pension 92. Like 30 years delay, then NESCO has not for predecessors. Right?
Mr. Rai,
we are following the regulation
of full pension for 20 years obtain instruction by the next state. Because Mr. Mohanty now says, he was responding to my query that OCS pension rules is applicable.
Question is, he is getting the pension. Not that he is not getting the pension. He claims that his DLR something like that post should be included.
Temporary service.
Temporary service. But after the regulation, from the date of regulation until his retirement, we are giving the pensions. No doubt he is not debarred from the getting pension. But question is whether that period will be calculated if he would not have eligible to get the pension. That is my submission. But here he is getting the pension from the date of.
I admit. Proper, but getting proportionate. Full pension, I am being deprived to get the full pension in spite of.
But Mr. Mahathi, when did you get regularized?
95.
95.
95.
So from 95, you retired in
2015.
2015, you worked for 20 years. For 20 years, did you get the 95 salaries, taking into account the past service?
My lord, this matter was under consideration of the regarding gratuity and pension before the Labour Court. Sorry, Assistant Labour Commissioner. So it's Assistant Labour Commissioner opined by the next.
When you approach the Assistant Labour Commissioner, the question is. Yes. The question is little bit nuanced, Mr. Mohanty.
My lord.
Suppose in 95, you wanted that benefit. You would have got in 95 actually.
95 ru pauchu.
95, you would have got the benefit of past service. Did you get that?
No.
Then how can you after retirement will get that?
No, my lord, the point is, when we approach for revision of.
Suppose now, Mr. Mohanty, the other difficulty is, you get regularized in 95. You work for how many years in the DLR capacity on animal?
And I'm 80 to 95.
80 from 80 to 95. Assume you get it from 80.
Right.
Somebody got regular selection, got appointed in the substantive post as per rules in 1990. Correct.
Right.
So who will get more pension? The person who is in service in 1990 or according to you from 1980?
90.
So the person who gets selected without court's interference, gets regular job, will get less pension. What is the mistake he has done?
Well, they are saying that.
No, these are the issues to be answered because
Well,
Mr. Ray,
ଟିକେ little bit କହୁଛି ଏଇ
ନାଇଁ
ଯେତେବେଳେ
ଆପଣଙ୍କ problem ହେଲା କଣ କହିଲେ apart from little bit କହିବା, you have to develop the habit of little bit ଶୁଣିବା.
ମାନେ ଏଇ
because
point ଟା
it's a serious deliberation in a courtroom. This can't be trivialized. Again, if you add on the entire past service of a person who is engaged DLR, you will be getting more pension than a person obviously who is got selected.
only pension, not other service benefit, seniority.
Sir, you are not sir. Other senior service benefit. Who is saying? Okay. In 1990, he should get, according to you, more pension or less pension?
More pension.
How can it is impossible? If your contention is to be accepted, this person gets the entire benefit of service from 19. He starts his service as from 1980 till 2025, 45 years. The
Well,
person
see,
the person who is getting regular appointment as helper in 1990 and retires in 2025, he is at 35 years of service. He cannot get.
ଏଇଥିରେ ତାଙ୍କର ଆମେ ଯୋଉ ସ୍କେଲ ଟା ଆମର ହଉଛି ପ୍ରେଜେଣ୍ଟ ଡିସ୍ପ୍ୟୁଟ ହଉଛି ଯୋଉ ସ୍କେଲ ରିଟାର୍ଡ କଲୁ ସେଇ ସ୍କେଲ 50% ଆମେ ପାଇବୁ ବଟ୍ वी आर गेटिंग प्रपोर्शनेट रूल 10 अनुसार ସେ ଆଡପ୍ଟ କଲେ ଓସିଏସ୍ ପେନ୍ସନ୍
Mr. Mahanti, one thing is that the period of shortage of qualifying service for pension.
Yes.
You look at OCS pension rules.
OCS 10.
Kindly read.
Rule 10.
So your submission is contrary to OCS pension rules.
Rule 10 टा
which rule 10 which part? Kindly read.
Yes.
Which part?
Yes, ma'am.
Chapter 3 is in sync with your submission.
Subject to the
पूराटा पढ़ोतु
my lord. Yes, yes. Qualifying service of the government servants shall commence from the date it takes charge of the post to which he is माने rule 10 pension rule 10 commencement of qualifying service.
ଆପଣ କାହିଁ ଚାଲୁଛନ୍ତି କୁହନ୍ତୁ ଟିକେ ମତେ ପସନ୍ଦ କି
Subject provisions of the rules qualifying service of a government servant shall commence from the date it
ନାଇଁ ଆପଣ ସେଟା ଆପଣ ଭୁଲ ପ୍ରୋଭିଜନ ଦେଖୁଛନ୍ତି
temporary.
10-11 is contrary to your submission. There is an exception carved out in this here, this rules. Yes, you may place it. You may place it in your way.
My lord.
Commencement of qualifying service.
Yes, subject to the provisions of these rules, qualifying service of the government servant shall commence from the date it takes charge of the post to which he is first appointed, either substantively or in officiating or temporary capacity.
Capacity is different, post is different. Rule 10 is contrary. Don't misunderstand the rule. Kindly just rule 10. Rule 10 you are looking at page ulta to nahi. Look at the word which he is first appointed. Then read rule 11. You will understand what you.
My lord.
Read rule 11.
Subject to provisions of herein after content, the service of the government servant shall qualify for pension if it conforms to the following three conditions, namely, the service must be under government, the employment must be in a pensionable establishment, post, the service must be paid by government.
So 10 and 11 exclude you from getting pension from 1980 to 1995. There is an exception carved out in the rule itself regarding qualifying service. Then look at 18. Read rule 18.
But 13 भी ठीक है अच्छी relationship. Conditions to which the service qualifies. Service does not.
10-11 is against you. So that doesn't.
But 10 level judgment is my lord. हम 80 division पे judgment करचंदी उठे.
सीधा अपन जरी 10 रो भूल interpretation हम अन्य judgment भी अच्छी ता against है ना.
नहीं से
10 रो interpretation जोटा 10 रो interpretation अपन जोटा कहउछन it's a incorrect interpretation. If you read the entire rule, then you will understand where you go. Then look at 18.
A person's.
Rule 18 कौन persons ले?
नहीं, a service does not qualify. Service does not qualify.
Heading ता पढ़िबे ना छाड़ी दो
conditions subject to which service qualifies. Service does not qualify for pension unless it is rendered in a pensionable establishment, post. The entire continuous temporary or officiating service under government without interruption in the same post or any other post shall count for the purpose of pension in respect of all categories of government servant except the following cases, namely, period of service in a non-pensionable establishment, period of service in a
1 to be पढ़िबे ना सेटा तो छाड़ी देले के
one
पण जहा पढुछन सेटा छाड़ी दोजन सब बेले 1 period of service.
1 period of service in a non-pensionable establishment.
So first is against you.
Period of service in the workers establishment. Period of service paid from contingencies, where the employee concerned resigns and is not again appointed to service under government, removed, dismissal,
or is removed
from public service.
Yes.
A probationer who is discharged from service for failure to pass the prescribed test or examination. A re-employed pensioner, government servant engaged in contract and government servant not whole in time employment of government. Service paid from local fund or trust fund. Service of an office paid by fees whether levied by law or under authority of the government or by commission. And Service paid out of grant in accordance with law or custom. 3. Notwithstanding,
slowly put that is in your favor.
Notwithstanding anything contained in clause 1 and 2, Roman 2 of Subrule 2, a person who is initially appointed by government in a watcher's establishment for a period of 5 years or more and is subsequently appointed to the same or another post in the temporary or substantial capacity in a pensionable establishment without interruption of duty, the period of service so rendered in watcher establishment shall qualify for pension under this rule.
So the period of service so rendered in watcher's establishment shall qualify for pension under this rule.
Again.
Temporary or substantive. Then read further. Rule 6 concerns you. Sub-rule 6, 18.6.
Again, notwithstanding anything contained in clause I 1 and 3 of Sub-rule 2, a person who is initially appointed in a job contract establishment and is subsequently brought over to the post created under regular pensionable establishment, so much of his job contract service period shall be added to the period of his qualifying service in regular establishment and would render him eligible for pension.
So the Punjab decision, Supreme Court decision. What is the decision?
Morning collection. Forget.
Anyway, you have an idea about
I've gone through.
that decision. He has not considered this rule 18, 4, 6, rule 18, 2, then 3, 4, 6. So your interpretation of the rule would be that the entire period for pension. If the entire period for pension is added, suppose now, the other aspect kindly also consider. You joined as a helper, retired as a helper. By adding the period past 10 years, you don't become a Group C or Group D. You don't get any promotion by that.
No other service unit.
No. Or service benefit. Service benefit. Service benefit is not being discussed. Let us not digress and jump around the issue. You seek pension. You work for from 1995 to 2025.
15.
2015. So 20 years you have served as a helper. Suppose by adding the earlier period, you will gain nothing also. Have you ever indicated in your petition that by adding that period, you will get say 1 rupee extra or more? No, because you will not get anything.
जो scale retired कली से scale रे मते दोचन proportionate.
You are not getting it. Unless you get that scale during your service life. That was the first question to you. Suppose you joined in 1995 as a helper. You get the pay scale. You accept that. So these are the issues to be answered by this court. Whether this order can be contrary to Rule 18, 10, 11, 13 and 18. And to my knowledge, there is no judgment of this court. Nullifying Rule 10 or 10 and 11 and 13. But yes, earlier, prior, this amendment was carried out in which year?
That's 90.
What is the date of amendment? What is the date of amendment of the insertion of that provision, notwithstanding anything? The such period which is sought for.
1/9/2001
1/9/2001. But prior to 1/9/2001, there are certain decisions of this court directing the same. The shortfall period shall be added to the service to get, which were confirmed by the Supreme Court also. Now the problem is the Punjab and Haryana High Court decision doesn't refer to any rules. Your submission is not also that I am getting 100 rupees, I will get 101 rupees. Because suppose one cannot get by working as a helper for 20 years, one reaches the maximum scale of pay. If you wanted to become the next, say, fitter, or say some other, what is that called? higher post of
helper, lineman.
Lineman, that is one. In factories, what is that called? Foreman. So maybe there is a case promotional. So unless you get those promotions, the decision you might be citing, I don't know. Nowhere it has been discussed. And obliterating rule 10, 11, 13, and also 18. 18 is express bar because it's not because pension is not a matter of, it's not a bounty, but it is also statutory. Everyone is not getting pension. So only the state government employee which qualifies is a pensionable establishment it gets, and 18 makes these exceptions that you add on this thing. Now suppose you become a foreman scale. So who the person who has somebody starts his career as a regular employee, retires as a regular employee, works only for 30 years or 20 years, much less than you. Because you started working in 1980, retired in
2015.
2015. So 35 years. 35 years, very few persons get to 30, max 32 also they can't achieve. Earlier 32 was there. So it will be reverse discrimination. Somebody, because he simply joined by getting selected regularly and retired regularly, of course, he cannot. Is there any law which adds years to the service of a regularly recruited person? Fine, you are saying discrimination. I am not getting pension after getting so many years, working so many years. Others are getting pension. Or the others are born in the establishment as a regular employee and they work and they retire. When they cannot be given that addition of 2, 3 years or 5 years or 10 years, how a person who himself admits that yes, I was not in service, I worked as a helper or a contingent employer or as a watch charge employee, these kind of whatever has been described in Rule 18, what you have just reading. And that sort of interpretation is also contrary to 18 also. That is the other difficulty. Because the rule is very specific. The period of shortage for regular pension is to be added. And I think that quite a good number of pronouncements are there. Mr. Das will also, Mr. Rai, they are aware of that. So that is the answer of Mr. Rai. Then what do you say? So Mr. Rai's answer is very simple. That you are regularized, you worked from 1990, 95, retired in 2015 for 20 years and you are getting the pension.
Well, I will clarify. See, जो मानक देई चंती, मोर last scale थिला 5,470. तो मतलब pension देई.
So the calculation of pension, if you are disputing, that's a different thing. Then why we have spent after Pokhara, we have spent around more than 30 minutes discussing addition of period and subtraction period. If you are saying calculation, then the answer would be different. That my pension is 5,000, I am getting so and so. So they have to answer that why he is giving less amount, say 4,500. But you are saying something else. That is not your submission throughout. Upon today, whatever you have submitted, that I am deprived of my pension because my past period of service in the contingency establishment is not taken into account. His answer is that, sir, he has been regularized, he is getting pension, and he has never disputed his pension also. Then make a prayer accordingly. If you want to the quantification of pension, fixation, that's a different thing. You see Mr. Mahanti, getting job is difficult. People all are not getting job by regularization. How many people getting a government job maybe in Group D? Getting selected? Do they commit any mistake by getting selected and for that they will be penalized for by wrong interpretation or whatever manner that they should get less? Suppose if you are saying that you are discriminated somebody who was regularized in 1995 and getting more pension, then you at least bring that on record so that he can answer. His answer is very simple. Mr. Subhranshu Bhushan Maharti for the petitioner, Mr. Devaranjan Rai for the opposite party. Here, Mr. Das, you are also appearing in some cases.
No, my Lord, Amit Misra. My Lord, out
Amit goes for opposite party को जो ना अमृत मिश्रा opposite party को पे अच्छा.
My Lord, ये जो पक्ष
Mr. राय हो चुकी ताले अलग अलग order करें. First matter है देवरंजन राय. Second, Mr. अमृत मिश्रा. अपना list लिखी दियो. Your name, sir? Acharya. Akash Acharya. Akansh. Item 1 is the Royla. So, one ta complete karo. Let us not mix it up. So, Subhanshu Bhushan Mahanti has been working for the petitioner, Mr. Devaranjan Rai for the opposite party. And counsel for the petitioner submits that the petitioners, after working since 1980 as helpers, in different, ଆପଣ କଣ କାମ କରୁଥିଲେ?
ମୁଁ ସେଇ ହେଲ୍ପର
ଖଲାସି ନା କଣ?
ନାଇଁ ଆମେ ହେଲ୍ପର କାମ କରୁଥିଲୁ ବଟ୍ ଷ୍ଟାଟସ୍ ୱାଜ୍ ଏନଏମ୍ଆର.
କଣ ଲେଖିଲେ? 1980 in nominal master role under the opposite party.
Erstwhile Orissa.
Erstwhile Orissa State Electricity Board. And OSCB टा कौन है लाकर?
OSCB टा Gridco.
Then Gridco. Then
Nesco.
Now
Nesco.
Now TPCOD.
TP NODL.
हाँ TP NODL. Sorry.
इतने change है लेने Mr. Rai भी भूल गए लेने. Mr. Rai was also appearing for OSCB. And at present TP
NODL.
Tata Power North Odisha Distribution Limited.
Northern Odisha.
TP NODL. Outer sequence का कोई दियों तो OSCB, Gridco, TP was regularized in service. It was brought into regular establishment in the year
1996.
In the year 1996. The petitioner retired from service on attaining age of superannuation.
31/5/15.
31/5/15. जोटा रेगुलरेशन to 6/7/96 कर दिया 1996 6/7/1996 Mr. Mahanti
6/7/1996
he submitted that the petitioners are getting pension but they are entitled to more amount of pension.
Well, it may take a little bit. Say गवर्नमेंट ऑर्डर टा बाहर कले 6/7/96 रे कि इफेक्टिव देले 19/9/95
मु तो आगे 95 डाकथिले आपण मते करेक्ट करतेले
सॉरी से लिखि इफेक्टिव डेट
आई कोन लिखले इस रेगुलेशन ता देखो with effect from 1995 1995
ना 19/95
At times, when you do not give the details, there is less chance of making mistake because that's not that will not be that relevant. The point of discussion is different. 1995. तापरे सनला कोठी pension. If the period of their service from 1980 to 1995 is added to the service. Para. Mr. Roy. Mr. Apno Ray lecture. Mr. Ray submits that the contentions raised by the petitioners are not correct. The petitioners are receiving pension as entitled thereto in accordance with the rules. It is also submitted by Mr. Rai and also agreed by Mr. Mahanti that the employer follows the Odisha Civil Service Pension Rules 1992. During course of argument today, the provisions contained in the OCS pension rules, 1992 rule 10, rules 10, 11, 12,
13 also, my lord.
13
As well as
and 18 were discussed in some length. Mr. Ray, in response to the submissions of Mr. Mohanty, submits that the OCS pension rules do not permit such addition of service apart from the provision that if there is any shortfall in the qualifying service for receiving pension, such period of the service under in the
temporary establishment.
specify karibani, such period of service in any establishment other than a pensionable establishment is added for getting qualifying service, for getting a pension, for getting pension. So Mohanty has adjournment to make his submissions on consent list on
July.
Yes, already say to July रे गोटे कोड आपण केबे दोछनी जल्दी करो 8/7/2025
My lord, with due respect,
please.
এই जो connected item रे से काउंटर रे मना करू ना खाली लिखिछन्ति जे he was not a
let us not say
selection
Mr. Mohanty
subscriber नोती.
So Mohanty, the court's job will not be that if they agree not to say no. That's not court's job.
Again.
If they give you your matter is rendered infructuous, that's different. So second matter रे
second से राजी ही जनी खाली कहउछ जे EPF टाणी देखेला हम दे देबो EPF slip
नहीं सीट रे कौन से कर let the court not step into the shoes of the employer.
आगे
आपन को से देबे अधिकार भी दे पारंती क्षेत्र कोन अछि कि
बुझी सर all are same.
Mahanti, Mr. Amrit Misra. For Mr. Akansh Acharya on behalf of Amrit Misra for the opposite party. Order of in view of the order passed in the connected WPC 19747 of 2019. List on date के बेको तो 8 on consent list on 8/7/25. Then the third sub item, same order.
Same.
Subhranshu Mahanti and Amrit Misra, Akansh Acharya. Fourth, same. Fifth also. No, fifth is not there. Call Karan.
27.
Obliged. Mr. P.K. Ponda for the petitioner. Mr. Baidhara Sahoo for the opposite party. For OP1, OP2 होचंती Baidhara Sahoo, OP1 होचंती Mr. Rajdeep Pradhan. On consent list on 2/7/25.
28.
Mr. S.K. Nath on behalf of P.K. Mahapatra for the petitioner. 28 for state. Mr. Pradhan. So Rajdeep Pradhan. AC for state on consent list on 9/7/25.
29.
List on date कर दियो तो.
I am from corporation, madam.
My lord, there was Mr. Florida, my lord, kind of after vacation. my lord.
Sorry.
Date
I didn't look at you actually. I was looking here. So what's your name, sir?
My name is Pramod Kumar Sahoo.
Mr. P.K. Sahoo.
Yes, my lord.
Mr. P.K. Sahoo on behalf of S.K. Parida.
Yes, my lord.
For the petitioner. Mr. Vibhudendra Das.
He is out of station. He requested me to present that.
Today the hearing matter is not possible also otherwise. If you agree to conclude a matter, then something is possible. Otherwise,
A date will fix now.
yes. You are appearing for ESI.
Right.
For anyone for present for union? OP1 none, OP2 to 4, 2, 3 and 4. 2, 3 and 4, Mr. Vibhudendra Das. On consent list on
14/7.
14/7/2025. Miss S. Ponda, Swagatika Ponda on behalf of P.K. Misra for the petitioner. So Rajdeep Pradhan, additional standing counsel. For opposite parties, 1 to 5. All opposite parties, sir, or the opposite parties. The Lord Counsel for the petitioner takes adjournment. As prayed for list on 8/7/25, interim order passed earlier shall continue till the next date of hearing. That copy may, so sit here, Mr. Pradhan, Mr. Mahanti is there. That copy is to be handed over to Mr. Swine.
Yes,
He
sir.
received it.
I have been told.
Yes. They receive for them.
But they, his junior is over here.
Call करो.
31.
The GC Ray, he got the Ray for the petitioner. Mr. Anshuman Sethi, additional standing counsel for the opposite parties. Constant list on. 207-25. Did you mention completely?
32.
तुमचे अर्जंट करते मला करते असं पोस्टिंग करते प्रोसीडिंग ना क्वेश्चन करते
33.
I am for the corporation opposite party.
I am opposite party, not three state bank of India.
थ्री के मेंशन करी ना petitioner नाम Mr. AP Ray, Amrendra Prasad Ray for OP1 and 2. Mr. Dilip Kumar Mahapatra for OP3. List on
7.
7-7-20-25. None appears for the petition.
34.
Mr. Gokulananda Padi, G.N. Padi for the petitioner. Mr. Anshuman Sethi, additional standing counsel for the opposite party. On consent list on the 11-7-25. Interim order passed earlier shall continue till the next date of hearing.
35.
Annapurna on behalf of Nitish Mishra for the petitioner, Mr. AP Rai for the opposite party. On consent list on 9-7-25, interim order to continue.
36.
J.K. Mahanti, Jajati Kishore, J.K. Mahanti for the petitioner, Mr. Anshuman Sethi, additional standing counsel for the opposite party. Learned counsel for the petitioner seeks adjournment. As prayed for list of 10-7-25, interim order to continue till the next date of hearing.
37.
Petitioner, sir.
32.
I am for
Yes.
the petitioner.
Yes, Mr. Mishra. Just a second. 32 is mentioned, so.
Yes.
Item 32, in this case, I filed a conflict petition, amendment petition.
Bringing in record the
New contempt, name of the.
this Babita Kumari Patnaik for the petitioner. Mr. Anshuman Sethi, additional standing counsel for the opposite party. The learned counsel for the petitioner submits that IA 135 of 25 has been filed for amendment of the cost guideline. To bring on record the present incumbent opposite parties. Copy of the IA is served in the learned IAC. Only that much.
Only that.
The prayer for amendment is allowed. Amended cost title will be filed within.
By tomorrow.
Within 2 working days.
By.
After vacation. list ଗୋଟେ date कर दियो
2/7
list on 2/7/2025 तो लड़े
Are a scheme appointment under rehabilitation assistance scheme.
but let us see it आपन Supreme Court judgment पर ही जाइथियो for that 2/7 you because Supreme Court they have said that they have taken a stand that the new scheme will not be applicable, they will be given appointment.
But
what exactly will happen in your case, one cannot say. The Learned Additional Standing Council shall obtain instruction from the newly added opposite parties
But
regarding compliance of the order dated dash, passed in dash.
Here,
So, Mr.
let's here your lordship may kindly see the order dated 13/5/2024. This honorable court, while entertaining the writ application, has stayed annexure 2 and 3. Annexure 2 is the 45A order demanding a sum of rupees 10,83,000.
Yes.
Then, my lords, in annexure 3, that is the notice of demand for to defaulter, there, my lord, same amount, but adding interest, they have claimed 14,99,000.
Yes.
Now, both the orders have been stayed by your lordships.
Yes.
Now, my lords, thereafter, my lords, in this annexure 4, that garnishee order has been issued by the recovery officer to the bank. They have not given a copy to the petitioner also. That is the requirement of law that a notice be issued to the petitioner. I am not aware of this garnish order. The bank did not allow me to operate my account.
This is item 37.
My lords. This
You
is
are referring to garnishee order at page?
At page, my lord, 6. I have filed the IA, my lords, in 80888.
से परदिन सर फोन करथिले से आज उठुछि किंतु अछि ऑर्डर से आसे कथा काली से भूल रे उठी गई छै
No, that is true. I have
हाई भी आछि सर सेक्शन
काली हिची
इडी आछि
अच्छा
My lord, copy is with me. My lord,
no, there is some problem in the listing. এটা আছে
only to allow me to operate the bank account, that's all.
Yes, Mr. Rai, what has happened? Why it is garnishee after
my
stay
lord,
order?
my lord, garnishee order, my learned friend not presenting the actual position, my lord. My lord, may kindly see annexure 4.
Yes.
That is that is issued in 2023, my lord.
Yes.
5/9/23.
Yes.
And writ application filed on 1/5/24.
Yes.
Order was passed.
No, that's not the question.
And my friend is submitting after passing of stay order, the recovery of.
No, that is not his submission.
No, I am not sorry.
That is a very oversimplified version of his submission. Let us not take any dates of 5/9/23, 1/5/44, 1/5/24. That's not important. His submission is that after operation of annexure 2 and annexure 3, that 45A order and the later dated 25/24/3 order have been stayed by this court, which in your presence, you are present. I was just looking at that. You also know that. By effect of this garnishee order, the bank is now asking them to stop operation. But yes, Mr. Misra,
bank is not.
So is it a mistake by the bank or what is because the date Mr. Rai is correctly pointed out?
Yes, my lord.
Not disputing also.
Absolutely correct, my lords. But that garnishee order is to be communicated to the petitioner. That they have not done. What they are doing, they are simply forwarding.
Mr. Ray, are you disputing that this garnishee order is result of annexure 2 and 3?
No, madam.
Correct.
Then it is a storm in a teacup. None of you are disputing anything. Mr. Misra, you also should have told the bank or the authority that they already stayed.
My lords, that I have done. I have approved the authority also. I have indicated in my application. They said that we'll revoke it. They took time.
No. Mr. Misra, I am not saying that. See, 5/9/2023 order, garnish order is not in the writ petition.
No, that was
Yes,
not.
now you are saying, Mr. Ray also says that annexure 2 and 3 have been stayed.
My lord.
Garnish order is a consequence of annexure 2 and 3. If I have
Correct.
understood correctly.
Yes, my lord. Yes.
So the obviously the stay order will operate. Maybe
Yes,
it is
my
not
lord.
mentioned.
Yes. So
IA
that may be
number,
different.
just a
That
second.
may be.
IA number 8088 of 2025.
My lord, may short submission. My lord, may direct ensuring the
Seek modification of that order, High Court order.
my lord.
See, don't make me a bank. It is strange.
Sorry, my
You, the order is passed in your presence. If you look at that order, you yourself, you are the counsel also.
my lord.
And you don't dispute that it has been stayed. So
My lord.
if it has been stayed, stayed. Is it rocket science to understand, or I don't understand this? Then if you want to do anything, you follow the procedure, whatever you want to do. No, I could not follow your submission. You want that I should ensure payment of that amount.
Keeping some amount.
That I cannot do. The High Court order is binding on me also.
Sorry.
Can a subsequent order be modified on my own perception? It cannot. That cannot be. Mr. Tripathi is suggesting.
No.
It is better he should sit quietly besides you. Yes. The IA 8088 of 2025 has been filed by the petitioner. IA order ಕೊಡ್ತಿದ್ದೆ. The IA was not available in the scanned copy. However, the office has provided the physical copy. Copy of the IA has been served on the learned counsel appearing for the appearance section. Oh, appearance okay. So Somnath Misra for the petitioner. Mr. A.P. Rai for the opposite party. Served on Mr. Rai, who has obtained instruction. So Mr. Learned Counsel for the petitioner submits that as a result of the garnish order annexed to the IA, marked as Annex 4, dated 5/9/2023. The bank party करचंती.
My party name Bank of Baroda, Paradip branch.
The Bank of Baroda.
असुविधा सेवडा बैंक को पार्टी कर
Bank party करा I'm challenging
Bank
that.
of Baroda, Paradip branch.
Madhuban.
The detail ta लिखिए para 7 में. आप उसको लिखिए para 7 So and so. Have frozen the account of the petitioner operated in the said branch. It is the learned counsel brings to the notice of this court the annexures 2 and 3. Annexure 2, that is ordered under 45-A of the ESA Act, order dated 29/11/2022, and the letter dated 28/4/2023. Which are subject matters of the writ petition, which are impugned in the writ petition. The Learned Counsel refers to the order number 1 dated, order number 2 dated 13/5/2024, passed in IA number 6196 of 224. Refers to so and so. Stop. By the said order dated 13/5/2024, interim stay of the annexure 2 and 3 were granted. The order is reproduced here. Para 2 reproduce order number 2. It is not disputed at the bar that the garnishing order under section 45 capital G of the ESI Act 1948 dated 5/9/23 into bracket annexure 4 communicated to the Bank of Baroda Paradip branch as indicated above is result of the order impugned orders dated 29/11/2022 and notice of demand dated 28/4/2023 which have been stayed by the interim order dated 13/5/2024 passed in IA number 6196 of 224. Mr. Ray in response submits that the order dated 5/9/2023 is prior to the order passed by this court. However, the said order was not annexed to the writ petition. However, it is not disputed. It is, however, fairly, it is not disputed that the garnishee order is consequence of the orders at annexure 2 and 3 in the writ petition. In such view of the matter, as an interim measure, in such view, in view of the discussions above, as an interim measure, it is directed that the order dated 5/9/2023 issued by the recovery officer, Regional Office, ESI Corporation, Bhubaneswar, addressed to branch manager so and so, para 7 under section 45G of the ESI Act shall not be given effect to till the next date of hearing.
The petitioner be allowed to operate the account, and the petitioner be allowed to operate.
So that order will not be given effect to, because whether for any other reason that cannot be so.
Yes. But sometimes the bank people they say no.
See, the bank people are not responding even.
Yes.
In another matter, the bank people did not. I had to direct for production of the. They are not responding because there is an urgency. Dusty notice is there. So let us see how they interpret.
Unless the ESI authority direct to for
the petitioner shall be allowed to operate the account if there is no other legal impediment. Apart from the letter dated 5/9/2020.
Yes. That is all.
My lord may say, today I have already filed the counter active in the writ application.
Should happen the section de the learned counsel for the out add for the writ petition WPC lekhonta tab tolu WPC kar dela WPC ette the learned counsel for the petition opposite party submits that he has filed a counter to the writ petition and copy serve hichi
to my associate, he has served a copy.
Copy of the counter has been served on the associate of the learned associate of Mr. Misra for the petitioner.
If required, I'll be filing a rejoinder after reopening.
So Misra submits that since he has received the copy of the counter today, he may be granted further time to obtain instruction and file rejoinder if so advised.
Interim order to continue in the writ petition.
List on kete date karo 15/7/2025 interim order dated 13/5/24 shall continue till the next date of hearing.
Item 39, my friend is there. I have already prepared the counter affidavit. My lord, may call this matter after vacation. I will file in the meantime.
15/7 no problem.
Just item 39 ta kitna kହୁchandi 15/7
15/7 same day or any day.
Item 39 lekhuntu Somnath Misra for the petitioner, Mr. AP Ray for the opposite party. The counsel for the opposite party submits that he has received instructions and filed counter. Unconscious list 15/7
file karna hai.
No, I have not recorded. No, file करचंती बोले I have said that he has received instruction. And will file counter or shall file. Yes.
Interim order to continue.
39 interim order dated so and so shall continue till the next date of it.
Deeply. May we say happy summer vacation to your lordships, my lords.
Thank you so much. Thank you so much. God bless.
Sir.
କୋର୍ଟ ଭ୍ୟାକେସନ କଣ ହେଲାଣି ଆଉ 2 ଦିନ ଅଛି ପା
अरे काली गोटे दिन लास्ट और किए देख No, but Mylord will come on 16th also. I am
पोस्टिंग कर दियो नॉन अपेरेंस करंतु नहीं आज मना कर सॉरी
40
Mr. Mohammed Fayaz for the petitioner. You are Fayaz or Riyaj?
Yes.
No, Mr. Mohammed Riyaj for the petitioner. Mr. Anshuman Sethi for the opposite party. This term. After vacation go chunti.
15/7.
Learned counsel for the petitioner 6 adjournment. List on 15/7 2025. What is the status of pleading?
Pleading has already been completed.
Complete. He submitted that pleadings are complete. Thank you.